In item number 7, my lord, the petitioner has filed one reply in affidavit on 4th November. That may be called for.
Yes, His Lordship. My Lord, in record of item number 5, we have filed an IA for substitution. During the pendency of the petition, the petitioner expired. Therefore, the wife filed a petition. However, the IA has not been in record. I pray that this,
What's the matter about?
my Lord, the petitioner has been terminated from the service on compulsory retirement. Compulsory retirement.
Then,
The crown that unauthorized leave.
so he's gone only on a compulsory retirement.
But it's not that he was diagnosed with some mental illness. Therefore, he didn't report on time.
It's okay, but it is not a punishment.
Lord,
Compulsory retirement is not a punishment.
during the pendency of the inquiry,
We'll see when the matter is taken up.
Yeah. Let's mention item number 19 of today's council. I'm paying for an accommodation, I cannot PCI today, any other day,
2017 matter.
that is there, any other day.
We will see whether it reaches. No accommodation. You have a lot of time. Prepare it now. You have your file with you.
Actually, whatever earlier, Sarma was there. I could not go through the.
Your name is appearing in.
No,
No, Mr. Goswami, your name is appearing in golden letters at the top of it. Don't come up with all this.
Let me prepare for it now.
Prepare it. You have time. This will take it up around.
That is going on, before your lordship.
So
I-
pray
Yeah,
to
there-
pray to God that the matter takes the whole day. Don't ask for an adjournment of a 2017 matter.
Lordship, I'd like to mention 15 Lordship, not 5 Lordship. Lordship, I'm not in the case Lordship. As per instruction of my second article, this matter has become a of the Lordship.
Ask that for any person to come. I can't make it infructuous at your.
Yes, Lordship. Then Lordship, pass over for the day Lordship because
No,
the council.
nothing will. We'll see. We'll dismiss it. Infructuous matter, dismissing it, very good. Much
Right.
easier for me.
Please, Your Lordship. Lordship, I'd like to mention item number 17, Lordship. Lordship, I am appearing on behalf of S. Kelder, Lordship. He is out of station. If Lordship may please to pass over the matter for the day, Lordship.
I told you, don't come up with this type of adjournments of a 2017 matter.
Yes, Lordship.
Other councils also given you this very thing that no adjournments in these type of matters which are of 2017. These are whole matters. People also should find out that 2017, 7 years is enough. And if you are not prepared,
Lordship, I am not the engaged counsel here.
fantastic. Then don't mention it. Go next.
Please, Your Lordship, my lord may not be inclined to take up item number 3 of the daily process.
Oh, yes. Item number 3 not be followed.
Much obliged.
May I please, concern of the other side, I beg, sir, item number 14 of today's daily list, madam. This is one of, Mr. engaged person, Mr. Vedanta Kosik is out of station due to his brother treatment, madam. He had
Who?
reversed his Vedanta Kosik, madam.
So what? Other persons are there, na? Titado,
He died no more, madam. He died,
Didas,
he died 2 years ago, madam.
Didas.
Didas, it no.
He also, he has also died.
No, no, madam.
Then?
A copy was there, madam.
No adjournments.
To take up tomorrow, madam.
No. Absolutely no. We can take it up at 5:30. Okay, tomorrow, 5:30.
Tomorrow.
No, tomorrow at 5:30 in the evening. Because I have to sit for additionally for your matter because I have already other matters. Tomorrow, we have already 52 items. So against that, another one more is 52. I finish it at by 5:15 and then do it. Don't come up with this type of agenda. No, nothing doing.
I've mentioned item 13 of today's. In this matter, Lordship, we have challenged, not challenged actually, Lordship. Some of our juniors got promoted prior to us, Lordship, and the names of those juniors are not before your Lordship. Lordship,
Interesting, non-joinder of necessary parties. On that ground, we'll dismiss it. Don't worry.
promotion take on that dates, Lordship.
Other two, same type of adjournment prayers? Okay. Next,
Please, your Lordship, item 21 to 23 in the top of the list may be taken up after some time. Mr. Sekret on the legs in court one.
we have another council, senior council who was waiting out there. We'll hear from him. Don't worry, because this was taken at the top of the list because there was a request made to be taken up as the top of the list. We are one senior council and I saw there were two senior councils. The other senior council will appear. Next.
Lordship, if I may, with the dry consent of the opposite side, Lordship, I would beg to mention item number 8 of the daily list, Lordship. My senior, Mr. Akim Somo, is extremely unwell and requests that the matter be taken up on a different date, Lordship.
We'll take it up.
Item 26, personal appearance.
Where's the commission?
Official tour to Egypt.
Two? Okay. Now, what is happening in this matter?
Hello, yesterday after
First of all, tell me, when the building permission is for G+2, is it permissible as per the bylaws to compound addition of floors? Is it permissible?
to some extent it is permissible.
To some extent, how is it permissible? Addition of floors, let's see. Tell me, how is it permissible as per to for addition of floors?
Session planner is also with me. He will be able to explain.
Yes.
Provision of building by law. For a 10% deviation.
No, addition of floors. Is it permissible? So a person, so are we to understand that if it is a G+2, it can become G+7 without a permission? How did you compound it?
Only 10% of the floor area is.
So the 10% of the floor area makes from G+2, it can go to G+7. Then how did it go? Then what actions have you taken? This is a repetition which has been pending for the last 8 years. What actions have you taken? The council comes up and informs this court to the effect that he doesn't have instructions. Why there is no instructions being given? Why no affidavit has been filed?
After
Are we to believe that section 337, which is the power being given to the commissioner, is to be selectively done so only in respect of A, but not to B? Or should this court lose the faith upon all actions being taken by the GMC so that later on we will take it everything with a pinch of salt? So the GMC in every case does something wrong, let us admit everything, we stay everything, and thereupon we'll see when the matter comes up as to whether it is right or wrong. You want that?
yesterday after taking the information from the land of township, and I have instructed the associate planner to hold an inspection so that we can take action against the violation.
Then what actions are you proposing to take? There is a civil court matter pending. There is suit pending. I'm shocked how a suit can at all be maintainable against a 337 proceedings. Isn't there a complete bar? There's no stay as regards, there's no injunction as regards 6 and 7 law. Why haven't you taken any action?
Take action after getting it.
Because yesterday I got another hold of another matter. Here is the case, the best part is this. You issue a notice saying that you did not have the permission for making construction of the building. But you grant the permission later on. And now you want to take action. It is something like you will now demolish at the cost of the petitioner in that case. And the petitioner will again build it because you have now given the permission to reconstruct at the cost of the petition. Is the GMC functioning in this manner? I'm sorry to say. When is the commissioner coming?
10th of November.
Yes. You have him. Because you don't have the power under 337 to issue any notice. You have the power under 337 to demolish. No. Neither you have. Let's hear the commissioner how it things work. It has been submitted by the pursuant to the order passed by this court on 6/11/2024. Mr. So-and-so. Your designation is? Mr. So-and-so, the additional commissioner of GMC. And Mr. So-and-so, the associate planner, is present. Taking into account that the power to be exercised under section 337 of the GMC Act 1971 is solely reserved upon the commissioner of the GMC. And it has been informed that the commissioner of GMC would be only back to Guwahati on 10th. Gusto, list this matter again on 11th of November 2024, on which day the commissioner GMC shall appear through video conferencing link to be provided by Mr. P. Nair, the learned standing counsel of the GMC, at 10:30 a.m. In the meantime, take some actions. 11. No, 11. Because he is not present. We are not concerned with anybody else. I want the commissioner out here, because the commissioner has to explain as to how this is possible. We take a word from the commissioner to that effect that if we lose the file, then the GMC would not take any action. We take the word from the GMC, the commissioner to that effect, that G+2 permission though granted, the GMC can compound till G+7. Let us take our words from those from the commissioner that these are permissible. Then we put it on our order so that for the remaining periods, if there is any violation by the commissioner, by the GMC, or you come up with anybody challenges, we can very well refer to that order at a later point of time. 11.
Yes, 11, your lordship is that.
11th is the date because he is back. I didn't want actually their presence. And the officers, I'm telling you, I don't want them, both of you or anybody, to be present out here in person. You have other works. Be present to the video conferencing.
Above the list, item 1 and 2.
So this is another method. Yes.
Praying for some
Mr. Advocate General. Mr. Advocate General. You are here in this side now. This is the other one, na, where he is claiming last time you appeared bonus. This is a case where Assam Tea Corporation, isn't that? The Assam Tea Corporation leased out a particular tea garden.
The council, he is appearing today.
But your
Little
name
later.
with golden letters appear.
Yes, I appeared, but thereafter they are not briefing me. In any case, if anything. I have a humble prayer, can this matter be taken up on 21st?
When?
21st. Lordship may keep it parted there, but
Not parted, but anyway.
21st, because some accommodation.
But there was no problem now as regards payment of bonus. Did you get any money from because there was no stay. I vacated the stay. Did you get the money to them? You paid the bonus. You are
Fine for the PM.
PF. So you pay the money to the bonus. So that is okay now being taken care of. Okay, we'll have it.
21st.
Well,
21st.
এখন নতুন ডিসকাউন্ট করবো there. So there is no impending urgency in the matter.
Not at the moment. The bonus part is over now. The puja is also. Already observed that it will be subject to.
Let's have it sometime near puja next time.
In the first week of December.
This matter again, I will take Mr. A. Ganguly, the Learned Council appearing on behalf of the petitioner in both the petitions 6 for an accommodation on account of his difficulties. Mr. Ashoma appearing on behalf, appearing on behalf of the PM authority submitted that during that the PM authorities have duly disbursed the bonus to the workers, who's taking into account the above. This matter again on 28th of January 2024. 28.
December.
No. December is too cold.
Limited list 21 to 25 of the list.
The other day, Lordship, I left two important provisions of the rules. To point out.
Like, yeah, I've seen the judgment of the Supreme Court in the case of delivered by Justice Sikri, where he was dealing with the 2015 amendment. Why it was brought in? It was brought in after the CIL dispute. So there was a question out there why it was necessary and what are the things. And if you go back to the law which was standing prior to the 2015, graphite was then also outside the first schedule. Then also it was the central government's permission was only necessary in respect to the first schedule. Then also, so there was no quarrel with that. Although the judgment says that now the difference which is being brought in now, in certain cases, more particularly Part C of Schedule 1, there is no necessity of the central government approval, but what is required is auctioning is going to happen. So this is what is now.
They want to promote auction. That was the main.
They are not to promote, they have, and more particularly in certain cases, they have only said that you can only go for a promotion, auction, more particularly falling under 11B. That is what it is at the 2015. Now 2021 brings in two provisos. These two provisos, of which one says that clause 10A to B is saved in under certain conditions. But The proviso makes an exception to this effect that in certain, if it is a pending application or there is an application for the purpose of granting of an lease, because your prospecting lease won't come in because you already have a prospecting lease. Granting of a mining lease, then it would lapse. Now, if that would lapse, if you don't have a mining lease, wouldn't the provider come into?
Yes,
This is the only question.
this is the only query and I have a straight answer to that. There is a vast difference between a mining lease deed and the grant of mining lease. I will distinguish that, Lord. These are two separate events, totally not connected with each other. If we have already obtained the grant of lease, that itself is end of a particular event. And those events are protected. I'll show by judgments also. The Karnataka High Court in two cases have dealt with it. And there is a distinction between the grant of lease and the execution of mining lease deed. If there is a two distinguishing things, Lordship, then we are protected and we do not come under the 2021's amendment.
So you therefore say that you already have a mining lease.
We already. And this
The
is just a
ex-
completion of the
The
formality.
execution of the mining lease deed is separate,
It's a separate.
which may happen at the subsequent.
Yes,
Sub-
it may take 6 months, it may take 2 years also, it may take 5 years also. There is no time limit for that. But once the decision has been taken and once the grant of mining lease has been given to me, then I have acquired a particular right. And those rights are protected, Lord.
Then let us see how do you grant a mining lease,
Yes.
by which provision?
How that rule 7. I'll come from 1 to 6. Mining
Where is that?
mining lease grant is page 63 of this compilation,
Page 63.
page 63.
Yes.
So up to 7, 1, 2, 3, 4, 5, 6, one chapter, and thereafter the other part. So let us come from 7.1. Right of a holder of a prospecting license to obtain a mining lease. So here the headline itself says mining lease. The holder of a prospecting license granted prior to January 2nd, 2015 or pursuant to Rule 5 may, upon fulfillment of the conditions specified in subclause 1 of subclause 4 of clause B of subsection 2 of 10A, makes an application to the state government for granting of mining lease. Lordship will kindly mark this also. Mining lease in the format specified in Schedule 6 within a period of 3 months after the expiry of the prospecting license or within such further period may not exceeding 6 months as may be extended by the state government. The state government shall send an acknowledgement of receipt of the application submitted under sub-rule 1 to the applicant in Schedule 2 within a period of 3 days of receipt of the application. I have placed this also. Provided that the holder of prospecting license who has made an application within the time limit specified in subclause 4 of clause B of subsection 2 of 10A to the state government for granting of mining lease before the commencement of this rule shall not be required to submit fresh application subject to the payment of the specified fees in sub-rule 3. 3. Application for grant of mining lease under sub-rule 1 shall be accompanied by a non-refundable fee of rupees 5 lakhs per square kilometer on a pro rata basis of the area over which the mining lease is applied for. Pursuant to subclause 4 of clause 4 B of subsection 2 of section 10A and
An existing.
an existing prospecting license holder may request for an extension of time for submission of the application referred in subsection 1 by submitting an application in writing to the state government in the format in Schedule 3. The state government shall accept or reject such request upon a period of 30 days from the date of receipt thereof.
You don't come within this.
Yes. Then 5, the state government shall have the right to seek an additional information, documents, clarifications from such application with respect to the application under sub-rule 1. So sub-rule 1 is for grant of mining lease. So these are the requirements stages which the state government will analyze. Thereafter, 6 comes. The state government shall, on being satisfied that the conditions specified in sub-clause 1 to sub-clause 4 of clause B of subsection 2 of 10A have been complied. So this all the above mentioned clauses are complied with within a period of 60 days from the date of receipt of the duly completed application, communicate to an order its decision to grant a mining lease for a mineral other than those specified in Schedule 1 of the Act. So our comes under Schedule 2. So this was issued to us. Forward the application to the central government for its previous approval in respect of first schedule. So B is not required for us. So up to this stage, one event is complete.
An order.
Order of what? Order of grant of lease. That order, I come, Lord.
It's decision to grant.
Decision to grant has to be fructified by an order of grant of lease, which I
Yes.
have annexed of 29 January 2000.
No, that I've seen it.
Yes,
But here it says communicate to and order its decision
yes.
to grant.
Decision to grant itself, because if we come later on, if we go to the language of 10, sub-rule 10,
Now we'll go there. Let us now come to 7.
7. In case of application received under sub-rule 1, which have not complied with the conditions specified in sub-clause 1 to Roman to 4 of clause B or subsection 2 of 10A, the state government may, after giving the applicant an opportunity of being heard and for reasons to be recorded in writing, communicated to the applicant, refuse to grant a mining lease. So we do not fall into that because they have already granted us. In case it was rejected, then we would have got an opportunity. 8. Where previous approval of the central government as required, so this is also not relevant because this is for the other part. 9. The state government shall, within a period of 60 days from the date of receipt of the decision of the central government, this is also not applicable to us. These two are not applicable. That is in respect of Schedule 1. Now coming to 10. Upon issuance of an order under clause A of sub-rule 6, we fall into that, or not sub-rule 9, that is regular Schedule 1. For grant of mining lease, what is that order? The order is for grant of mining lease. That is not a decision. What we have obtained on 29 January 2021 is an order issued by them for grant of a mining lease, not a decision which was communicated to us.
What?
It was not a decision which was communicated, that we have taken a decision, we are communicating. No, they have taken a decision and it has been communicated us in the form of a grant of mining lease. I'll place a judgment that will clarify a lot here. But my submission is that which the authorities who I'll be relying, I am on the same line. So this stage, that when it says communicate through an order its decision to grant the mining lease for the mining other than so and so. So this communication which is indicated in this 6 sub-rule 10, that order is grant of mining lease. The order which is mentioned in 10, upon issuance of an order under clause A of sub-rule 6 for grant of mining lease. Here there is no indication of my decision. The applicant for such mining lease shall, thereafter I have to do certain formalities. These are the exercise I have to conduct to proceed to the next event. What is that next event? The next event is to execute the next stage is to execute the mining lease deed. Once we execute that, then our operational part will come. May I read now 10A. Obtain all consent, approval, permit, no objection as required under applicable laws for commencement of the mining operation. So an order for grant of mining lease is not enough, which will allow me to start a mining operation. So we have to do certain formalities, certain requirements, which is given, prescribed in 10 A, B, C, D. So A says obtain all consents approval. So mining plan approval we have to obtain. Permit, no objection as it may be required under applicable laws for commencement of mining operation. 2, provide a performance security to the state in the form of a bank guarantee as per format specified in Schedule 4 or as a security deposit for an amount equivalent to 0.50% of the value of the estimated resource, which performance security may be invoked by the state government as per the terms and conditions of mine development and production agreement and the mining lease deed. The performance security shall be adjusted every 5 years so that it continues to correspond to 0.50% of the reassessed value of estimated resources. So we have to deposit a performance security. C, satisfy the conditions with respect to the mining plan specified in clause B of subsection 2 of section 5. So we have to obtain a mining plan and we have to specifically fulfill and satisfy all the conditions as indicated as prescribed in the mining plan, approved mining plan. D, sign a mine development.
You had this
We have this.
and this was cancelled. That
This
is
was,
why you
approval was withdrawn.
withdrawn, so you are before this.
Absolutely.
So this is C.
So in the second stage, we have facing this problem. Till now, our mining lease grant is intact. I'm repeating, Lordship. And that is the domain of the state government. Mining permission is the domain of the IBM. So state is empowered under clause, under one of the power is under entry 2 of list, entry 25 of list 2. Now going further, D, sign a mine development and production agreement with the state government as per the format prescribed by the central government after compliance of conditions specified in clause A, B, C of this sub-rule.
So this has not been done
This is also not been done.
because A is not been complied with till now.
A, B, C, D, we are at this stage.
You had only C,
We have C,
but A and B is yet to be done.
A and B, because it is in the process, because we have to get certain permission from the Ministry of Environment and Science. Forest, 5, 11 now. Now this is the second, the other event.
Hmm.
The state government shall execute a mining business and applicant the format specified in 7, within 90 days of fulfillment of the conditions specified in sub-rule 10. And if no such deed is executed within the said period due to any default on the part of the applicant, the state government may revoke the order granting the lease. 7.6, Lordship. And in that event, fees paid under sub-rule 3 shall be forfeited to the state government. So no further order is required to be given to us. Once the grant has been given to us on 29th of January 2021. The only part that is a formality we have to complete before starting the mining operation is that we fulfill A, B, C, D, execute the deed and start the operation. The state government role is only limited to the execution of the lease deed. And that has been clarified in 2-3 judgments, Lordship. I'll please. So Lordship will see where I'm stretching the state government, if we do not fulfill that, if we do not execute the mining deed, mining lease deed within 90 days of fulfilling all the conditions, then the state government may revoke the order of granting the lease. So the deed part is totally different. So they have taken a decision to rent out a particular home to me. Decision is communicated to me. Subsequently, I pay some money, etc., etc. Then you execute the deed. But the decision to give me the grant or give me the, in case of a suppose a premise, if they have taken a decision to give it on rent to me, that is final. Now complete the formalities. So that is a, basically these are all formalities which has to be done pursuant to the order issued under 7.6. 7.6 is culminating of the main process. The second stage, which is not contemplated. Therefore, the statement of reasons and objects very clearly says the pending process not culminating to the grant of mining lease. Those are protected. Let us go to once more to that page, Lord. Page 147. To close the pending cases of non-auction concession holders which have not resulted in granting of mining lease despite passage of considerable time for more than 5 years. The existence of these cases is anachronistic and antagonistic. So what is left out? Not resulting in grant of mining lease. All the cases which are pending at the stage of 10 ABCD. 7, 1, 2, 3, 4. Before coming to 6. All the cases which falls under 7, 1, 2, 3, 4, 5. These cases
So,
are,
Are you
these
saying,
cases will lapse.
are you saying that order to grant the mining lease, which is conceptualized in 7.6, is the grant of mining lease to you which have been given on 29/1/2000?
Yes, yes.
So if that be so, as per the definition of section 3C, you can undertake mining operation?
No.
Why?
We have
it is
to,
the mining
we,
lease.
no. After they have taken a decision that they will grant me the mining lease. And accordingly, they have issued an order to grant me mining lease. Right, Lordship? Thereafter, under that grant, I have to fulfill all the requirements under 10 ABCD. Once we complete this ABCD, then we have to execute the mining lease. Thereafter, mining lease date, then we can go for mining operation.
So that means it cannot be a mining lease.
It is a mining lease.
If it is the mining lease, you can go for under the mining. Let's see the definition of mining lease in 3C.
Lordship, we can come to A, 10A.
Hmm.
Obtain all consent
Now then I've seen, these are the requirements. You have
for
seen,
commencement of mining operations.
understood. Everything is that, therefore I'm saying, if we are to consider that a grant of mining lease, which have been given on 29/1/2021 or 22, is the mining lease itself. You see, there is a, what you are trying to distinguish, that there's the order of mining lease to order by which to convey the decision that a grant of mining lease will be given is different from mining lease.
No. Lordship will kindly come to see the definition now.
Of 3C. Yeah, this is here.
Mining lease says means a lease granted for the purpose of undertaking mining operation, including sublease granted for such purposes.
Once this is being given, you can undertake.
No. After mining lease deed only we can start the operation, because after granting of mining lease also, we have to obtain certain permissions, approval, etc. The two different facts, two different situations are, Lordship. One is mining lease and the other one is mining lease deed.
Now kindly come to number 13, 713.
Yes.
The mining lease executed on the 11th shall be registered.
Within 30 days.
Yes, but
From the
whatever
date
it
of
is,
its execution.
yes. So this is the mining lease.
Deed.
Yes. Because as per your Assam,
The mining lease executed under sub-rule 11. So what is sub-rule 11? Sub-rule 11
The
is
mining
mining
lease
lease deed.
The mining lease deed.
Deed.
Now, I'm yet to see here, but although some reference can be seen in 11, as per the Assam minor minerals concession rules, unless you don't have a deed, you cannot proceed, or you have no right over it. Because the mining lease, on the basis of just an order being passed, can you have a mining lease?
Here, the sequence of events is laid down in such a way
Hmm.
that at one stage, the grant has been given for mining. That has been done. Thereafter, also certain formalities has to be fulfilled. But at the moment I received the grant of mining lease, one event is over. And that particular situation, suppose if this reasons and object says that those cases not culminating at the stage of executing of mining lease deed, then things would have been different. Let us come to 147. Suppose not resulting in execution of mining lease deed. Suppose if we let us replace this situation. If we replace these three words, Lordship got it?
Yeah.
4. To close the pending cases of non-auction concession holders which have not resulted in granting of mining lease. Instead of granting of mining lease, let us put a word execution of mining lease deed. That situation would cover what they are saying. Then I am out. So there is a huge difference. I will substantiate my submission with the judgment, Lordship, that granting of mining lease deed, mining lease and execution of mining lease deed are two totally separate events. And the second situation is not covered. The first situation is protected under this 2021 amendment. For that, straightway I will go to the 1967 Supreme Court judgment. It's a constitution bench judgment. 1966 Supreme Court online. Or I can, yes. Page 126. And on the basis of this judgment, the Karnataka High Court passed two judgments, which will further clarify. Here, straightway Lordship would kindly come to paragraph 7. The granting of a lease is different from the formal execution of the lease deed. The Mineral Concession Rules 1949 made under Section 5 of the 1948 Act and hereinafter referred to as the 1949 rules deals with the procedures for granting of mining leases in respect of land in which the minerals belong to the government under Chapter 4. Rule 27 deals with the applications for mining leases. Rule 28A provides that when a mining lease is granted, the formal lease shall be executed within 6 months of the order sanctioning the lease. And if no such lease is executed within the aforesaid period, the order sanctioning the lease shall be deemed to have been revoked. It is really the sanctioning of the lease which amounts to granting of the lease. Execution of the formal lease is only compliance with the legal requirements to make the grant legally enforceable. It is very clear the first line and the last line of this paragraph.
Let us see the rule 27.
Of the earlier one. This is the old rule.
But this has a relevance because whether the word is there, order, convey the decision, issue an order conveying its decision to grant the mining lease is what it is there in 7.6. What has been mentioned in Rule 27?
Forty-nine rules, Lordship. We have 60 rules. We have.
This is done under the 49 rules. Mineral concession rules. You'll find it.
Then that if you look at the 1960 rule, rule 31. I think 49.
So the wording has to be seen. Whether it uses the word which is
No.
there.
Yes, Lord.
Yes, I understand. Tomorrow, just for example, normally in many cases, if the allotment is being given in respect of any land or anything, if the governor has already conveyed the decision to allot the land, that is done. The formal issuance of the patta is only,
the
is only
execution of the deed. Yes.
formalizing. That is understood. But when the word used in section rule 7(6) is an order
Decision.
conveying its decision to grant. Whether then can it be said it amounts to grant? Because one has to also take a important aspect out here is regarding uh, the things have changed in 2015 a lot. There are many aspects whereby earlier, which was the power which was there uh, in 2015 is there, but there are a lot of changes which have happened,
Yes.
whereby the
New
state's
rules came in
power,
2016.
state's power has been in a lot has been removed, taken away.
Diluted.
Because earlier, everything the state had to do after taking the consultation with the central government, now states have been given the power in many aspects.
But here, the language, although Lordship is saying that 7(6), it is the decision. But the decision is conveyed in the form of grant of mining lease. And that is why 10 very clearly says, 10 actually clarifies. If you look from that perspective. And further fortified by 11. So let us come to 6 again, Lordship. Communicate through an order its decision to grant the mining lease. So now 6A. Now when 6A is mentioned in 10, 710, upon issuance of an order under clause 6, clause A of rule sub-rule 6, for grant of mining lease. Here not decision of grant. We
Right.
have to read conjointly and harmoniously. Now 710 says, upon issuance of an order under clause A of sub-rule 6. So sub-rule 6 says, communicate through an order its decision to grant of lease. Now, when in 10, if we go, if we harmonize both 6 and 10, we have to read it in this way. Upon issuance of an order under clause A of subrule 6 for grant of a mining lease. So this is very clear. This is that it is not the decision. It's the grant of mining lease. Coming to 11 now. The state government shall execute a mining lease with the application format so and so within 90 days for fulfillment of the conditions under subrule 10. And if no such deed is executed within the said period due to any default on the part of the applicant, the state government may revoke the order, not the decision. Granting, the state government may revoke the order of granting the lease. Further, we have to see the language. Is considered. The order. Page 86. Page 86 of the reputation. And this practice is followed in all other states also, Lord. It is not that only Arunachal have written this. I'll place two judgments where the orders of 7-6 are issued. Grant of mining lease. Subject. In exercise of power conferred under subsection 2 of section 5 of the Mines and Minerals Development, Government of Arunachal hereby grants the mining lease, not decision. So grants the mining lease for graphite for an area of so and so in Subansiri for a period of 50 years in accordance with the provisions of the existing rules, subject to compliance of the provisions of the said act and rules. So subject to compliance means 10 and 11. Made thereunder, including Forest Conservation Act 1980, other laws in force for time being, the codes, etc. And next conditions, Lordship will kindly see. Yes. Terms and page 87. The grant of mining lease is subject. Here also no decision is mentioned. The grant of mining lease is subject to the following conditions. The mining lease holder shall obtain environment clearance from state government, state environment protection impact assessment authority, and from the government of India. And if it is community non-forest land, then consent from the community and local landowners should also be obtained. The mining lease holder shall obtain all consent, approval, permit, no objection as may be required under applicable laws from the concerned authorities before the commencement of the mining operation. So only a mining lease holder can apply all this. Without being a holder of the mining lease, I cannot proceed any further. 3. Shall provide a performance security to the state government as prescribed under so and so after compliance of the above conditions in para 1 and 2 before commencement of the mining operation. 4. Sign a mine development and production agreement. 5. After compliance of the conditions specified in clause para 1, 2, 3, 4, every mining lease shall be subject to the following conditions as per Rule 12 of the Mining Other so and so Rule 2016. Here C will come, the lessee shall. So I am already a lessee, a leaseholder. The lessee shall commence mining operations within 3 years from the date of execution of the mining lease deed and shall thereafter conduct such operation in a proper, skillful and workmanlike manner. So once I obtained this order on 29 January 2021, whereby I was granted mining lease, I become a lessee. I am a mining lease holder, I am a mining lease lessee. Execution is a subsequent formality we have to do by fulfilling some other additional terms and conditions, which are given in the same grant of lease, mining lease, which are directly a replica of the requirements under 17.
So here, how long you have been given this mining lease
50 years.
from?
It will start from the date of execution of the mining lease. Mining lease date. That date will start
How do
That
you say so?
713.
Huh?
713 of the rules
No, not the rule, from this document.
from this document.
Yes, because this document, if it is a lease,
Yes.
it has to start from somewhere and end somewhere. Where?
Here, what is there? 86. So it will be governed by all existing rules that is directly indicated there. So from which date the mining lease period will start, Lordship, that will have to rely upon the statutory rules. But in rule 13 also it is given 713. Let me see whether in the
Just for example.
order also it has
No,
given.
kindly come to 87.
There are a lot of conditions I haven't gone through, but it will comment.
Page
Let us
87. Clause 5A. After compliance of the specified conditions in para 1 to 3, every mining lease shall be subjected to the following conditions as so and so. In addition to the payment to be made by the lessee under chapter 13 of these rules, the lessee shall pay for every year except the first year of lease, yearly dead rent at the rate specified, and if the lease permits the working of more than one mineral in the same, the state government shall charge, provided the lessee shall be liable to pay the aggregate of the royalty in respect to so and so. Now, are you making payment?
till now, no.
So therefore, how
We have to pay when?
how do you take this to be a mining lease?
No, we have to pay performance security, etc.
No, but if you are not, therefore I'm asking, when did the lease start?
The lease will start. The lease will start from the date we start operation. And also registration is very important. 713, let us see, Lord. Page 64. The mining lease executed under sub-rule 11 shall be registered within 30 days from the date of its execution, and the commencement of the period for which the mining lease is granted shall be the date on which the duly registered mining lease deed is registered. So it will start from that day.
Therefore, I put that question to you while saying about 713. If that is so, can you construe this to be
Lordship,
the mining lease?
What we are saying here, one is we need protection and we need exemption from the amendment of 2021. That is the pure picture. That particular amendment, whether it covers this stage up to 713 or it covers up to 7.6, that is the core issue. The core issue is that if we are
Or in other words, whether in order to grant a mining lease by the government could cover the requirement under 7, the proviso.
I could not follow, Lord.
An order, you see, there are two aspects. One, an order. This is an order by which a mining lease is being granted. Or is it the formal execution of the mining lease, which is the question for your, as per your submission, when an compliance has already been done in respect till 7.6 is done,
Yes.
7.6A, then you are taken out of the proviso.
Yes. That is the picture.
I understand that
Yes.
submission.
So my submission is that those which are exempted or excluded from the amendment, I fall into that category, and that category does not envisage compliance of 7 up to 7:30. It envisages from 7, 1, 2, 3, 4, 5, 6. Those who have complied and completed all the acts as prescribed under Rule 7, 1, 2, 3, 4, 5, 6, whether they are excluded from the purview of the 2021 amendment. My submission is very clear. If we look at the language of the statement of reasons and objects read with the amendment, I am out.
Because you see, and the proviso and what you are saying, referring to page 147, those are in respect to pending applications.
Pending application.
Now, if you see the proviso, it says, as regards others, including pending application. The word is including
I
pending.
am not a pending application
You are
before the state authority.
You are not a pending application.
I am not a pending applicant.
Would you come in the first part prior to the pending?
Let us come to 13. Now page 153. Let us read very slowly, Lord. Provided.
Yes.
Provided that for the cases covered under this clause, including pending cases,
So,
including pending cases
so
of what?
therefore, including pending cases,
Comma, there is a comma. Then what are the pending cases? The right to obtain a prospecting license, I do have, so I do not fall, followed by a mining lease. So those who have applied for protecting license and waiting for a mining lease, their case is covered here, or a mining lease. I have already got a mining lease. So my application is not pending at the stage of getting a mining lease. I have already overcome that stage. I have already crossed the hill.
so again, the question therefore is as to whether an order issued by the government granting you a mining lease amounts to a mining lease.
Yes, that is a question. I have a direct answer from the Karnataka High Court, 2 judgments.
And there is another argument which you may have apart from that. 711 say the state government may revoke, but the state government has not.
Has not.
You see, the option is being given to the state government. Let us see again 711. It says the state government may revoke, which the state government has not.
If I do not execute the deed,
If you don't do it within 90 days, the state government may.
all the permission.
Here
Under
it is-
10, after as indicated in sub-rule 10, not sub-rule 6.
No, you can you see? Page here. The state government may revoke the order granting the lease. And in that event, the fee paid so and so. But the state government having not done so.
Because that situation has not arisen. Because to get the cause of action for revocation of my mining lease,
No.
I have to obtain all the permissions as NV says, as prescribed under sub-rule 10 ABCD. Thereafter, I fail to execute the deed within 90 days. Then only that cause of action will arise. That cause of action has not arisen.
Yes, let us see here.
The judgment lordship. The first lordship will kindly take 2019 4 AKR, page 111. Meena Lakhotia. This is also division bench judgment. Paragraph 10. On 10 June 2011, the Director of Mines and Geology has passed the following order, Government of Karnataka, etc. In pursuance of Section 5, read with Section 8 of Mines and Mineral Development Regulation Act 1957, and in exercise of power delegated under the state government notification dated 27/5/1995, the Director of Mines and Geology hereby sanctions grant of mining lease for limestone and dolomite, etc. in so and so, subject to compliance of the Mining and Mineral Act 1957 and MCR 1960, amended from time to time, and other applicable rules, the environment protection, so and so, EIA notification, etc. So here also, the sanction was for grant of mining lease.
But here the court has not taken into consideration seven.
Let me place the whole judgment. The grant of mining lease is subject to terms and conditions stipulated in Rule MCR 1960 as appended herewith. The grantee should exercise the mining lease deed within 6 months from the date of notification, because earlier there was a specification that within 6 months of Rule 31 of the 1960 rules, failing which. Now, this letter was issued to Meena Alahotia. 11. The above notification is issued in pursuance of Section 5 and 8 of the MMDR Act 1957. The Director has issued the notification in exercise of the power delegated by the state government to a specific query made by us as to whether any further government order was necessary before executing the mining lease. It was fairly submitted by the learned advocate, Additional Advocate General, that no further order was necessary. He further submitted that in view of amendment of 2015, the petitioner's case has been considered under 10A to C. Our case is A to B here, because we are on protecting license. They are under letter of intent. Placing reliance on the paragraph of 1221 of a division bench decision in Honorable High Court of Madhya Pradesh, so and so, reported in some connected cases, he argued that the provisions of Amendment Act are applicable to the facts of this case. Paragraph 12. In the case of Gujarat Pottery Works versus BP Sood of mining leases for India, etc., 1960, which I have placed, the paragraph 7 is quoted here. The granting of lease is different from formal execution of lease deed. The Minerals Concession Rules 1949 made under Section 5 of the 1948 Act, and hereinafter referred to as the 1949 rules, deals with the procedure for the grant of mining lease in respect of land in which minerals belonging to government under Chapter 4. Rule 27 deals with applications for mining leases, deals with the application of mining. Rule 28 provides that when a mining lease is granted, the formal lease shall be executed within 6 months of the order sanctioning the lease, and if no such lease is executed within the aforesaid period, the order sanctioning the lease shall deem to have been revoked. It is really the sanctioning of the lease which amounts to granting of the lease. Execution of the formal lease is only compliance of the legal requirement to make the grant legally enforceable. Now, coming to paragraph 15 now. In contradistinction of in the case, on the hand, the state government has granted the mining lease to the petitioner. Therefore, in our considered view, the ratio in Gujarat Potteries Work AIR so and so is applicable to the facts of the case on hand. The provisions of Section 10A to C of Amendment Act is applicable where the central government have communicated their previous approval required under Section 5(1) of the MMDR Act 1957. The petitioner's mining lease has been granted in pursuance of Section 5 and 8. Therefore, in our considered view, Section 10A to C of the Amendment Act is not applicable to the facts of the case. So there is a subsequent judgment where it is more clearly elaborated. Again, from the division bench of Karnataka. In fact, one of the judges is a Supreme Court judge now. 2019 SCC Online Karnataka 3791, paragraph 7 and 8. 7 and 10, Lord. Have Lordship got it? Perusal of subsection 1 of 10A of the said Act of 1957 shows that obviously it deals with those applications for grant of lease which are not disposed of as on 12th January 2015. This case is clear as subsection 1 of section 10A of the said Act of 1957 provides that all applications received prior to 12th January 2015 shall become ineligible. Wherever the applications were already decided and the state government has taken a decision to grant mining lease prior to 12th January 2015, obviously subsection 1 of section 10A of the said Act of 1957 have no application. Subsection 1 of section 10A does not make any application eligible which is already decided. We fall into this. Where the application is already decided prior to 12th January 2015, there will not be any occasion for invoking the provisions of subsection 2 of section 10A of the said Act of 1957. In the present case, the application made under Rule 22(1) of the said rules of 1960 was already disposed of by the order dated 19th June 2010 by the state government by passing an order for grant of the mining lease. This is what we are sketching upon. So it is also not a pending case, just like us. There also, the order was passed for granting of the mining lease.
When was 7/6 brought in?
7/6 brought in 2016. 2016.
These are 2016. No? That is why these are rules are not, the judgments have no relevance.
Lordship can distinguish in that way. But
No,
the
I'm
thing is that
asking you.
ratio, the principle is very
But
clear.
These judgments, that
But
is why,
The earlier rules and
because
present
they
rules,
were earlier following the mineral concession rules 1960.
1960 and this, what is the difference? Basic Rule 31. Rule 31 is a basic difference is that it has been segregated now into two stages.
You see, let us see how 1960 mineral concession rules 1960 was taken.
Yes, we have please. Rule 22. No, number 31. Yes. Rule 22. If Lordship is page 47.
This is the application. How it will be proceeded?
An application for grant of mining lease in respect of land which the mineral base, the government shall be made to the state government in Form 1 through such officers as every application for the grant of renewal of the mining shall be accompanied by so and so. Now coming to 4. 22(4). On receipt of the application for the grant of mining lease, the state government shall take a decision. Here also decision what is here. To grant precise area for the said purpose and communicate such decision to the applicant. On receipt of the communication from the state government on the precise area to be granted, the applicant shall submit mining plan within period of 6 months of such other period as may be allowed by the state government to the central government for its approval. The applicant shall submit the mining plan duly approved by the central government and by an officer duly authorized by the central government to the state to grant mining lease over that area. So this order which was issued here. The basic difference from the earlier rule and present rule is that our earlier situation, Lordship, the mining plan was to be submitted before grant of mining lease. And thereafter, Rule 31. Where an application for the grant of a mining lease, an order has been made for the grant of such lease. A lease deed in Form K or in a form as near thereto as
We are reading
circumstances
31, no?
is Rule 31. Lease to be executed within 6 months. Where an application for the grant of mining lease, an order has been made for the grant of such lease. So we are on this. That grant has been given. A lease deed in Form K or in form as near thereto as circumstances of each case may require shall be executed within 6 months of the order or within such other further period as the state government may allow in this behalf. And if no such lease deed is executed within the said period due to any default on the part of the applicant, the state government may revoke the order granting the lease, and in that event, the application fee shall be forfeited to the state government.
711.
7.
But when you see here, an order has been made for grant of such lease.
Yes, here also, we cannot read whatever is not written.
No. Finally, therefore, P
Page
76.
86, what is that?
76A say communicate through an order its decision. There's a difference out there. It's decision.
Now, they have communicated a decision. But what order I have received,
That's a different thing.
that is the thing, Lord.
Now, could that have been passed, issued? That is
That is the
question.
order.
No, would that have been issued?
If we look at the, in Karnataka High Court, once that order is issued, no further action on part of the government is required, except
No, because Karnataka High Court happened in a situation when these 1960 rules were holding the field.
like, what is the basic difference here? The basic difference here is that before granting a mining lease, earlier, mining plan was to be submitted and approved. Now, that situation is taken away. Now, we have to get the mining lease first, then thereafter we have to plan, apply for the mining plan as well as other permission. Twenty 19.
But for 2010. That is
No,
for 2010.
Let me argue, Lordship. Now, what is the actual situation? The actual situation is that if we look, what is a pending case? The pending case is very clearly indicated, Lordship, as both in the proviso as well as in the statement of reason and objects. Reason and object says, provided that for the cases covered under this clause, including the pending cases, the right to obtain a prospecting license followed by a mining lease. So this is, I do not fall because I had a prospecting license and I already have a mining lease. Or an application pending for getting a mining lease. In both situations, I am not covered. And therefore, I have already obtained the mining lease. Only thing is that mining lease deed is yet to be executed because that is not required, mandatory, to fulfill all these conditions prior to issuance of the order for grant of mining lease. The grant of mining lease, we have to look at the language. And none of the orders which order authorities I have placed, there is no communication of the decision. It is the grant.
I'm the first person to deal with the proviso. Yes, that is good. There's no judgments. I searched so much. There's no judgments on the proviso.
Entrepreneur, that is also a
Proviso of 2021, there's no judgments till now.
Lordship will be the pioneer.
So let us do one thing. I've understood the point. Let us get hold of them first. I'll give you a chance to reply.
Because I have not wrapped up. Let Lordship hear them.
What additional question you have?
I have to sum up my whole thing, including the
I'm going to
actually
give you-
this issue.
No, Mr.
If-
Mr. Saikia, I'm going to give you that opportunity. Don't worry with that. I'm going to give you the opportunity. But this is, that, let me get a something, what they are saying,
Lordship,
going to
yes.
say.
I'll get a rest
Yes.
also.
You also get some rest. And the second thing is, any other point you have apart from this?
Jurisdiction I have,
That you have said.
I
Because
have
the,
not elaborated.
no, I've understood. You
Yes.
say, as per you,
In fact, if Lordship
Who-
decides the matter on jurisdiction, the subsequent points will not be relevant. Or if Lordship,
No, I-
without going to
no,
the other
I
aspect, if
can-
Lordship is pleased
No,
to
no,
take up as a
because what
preliminary
is-
issue.
So, Saikia, the problem which arises, I would have only touched the jurisdiction if it was only later. What he said, the first part he said, that he has not, there couldn't have been a mining lease at all, taking into account that these were not there.
There also, he does not have the jurisdiction. That part also I will argue.
No, understood. He says that. And the second part, therefore, he says that in view of the fact that there is no mining lease, by virtue of this proviso, you are out. So accordingly, it goes. Now, if I only touch on the question of
There is
jurisdiction.
another major change,
Yes.
paradigm shift in the act. Earlier, 5A and B, there was a word and. That and has been also removed in 2008 in the amendment.
Which one? Rule. Section 5.
Even then also he is false. Even suppose let us assume that he has jurisdiction.
But what do you say about 17?
7,
You may say, here the Madhya Pradesh High Court judgment which you are referring to is saying about section 5.
section 5.
Now, what do you say about rule 17 of the rules?
Rule
81.
17.
Yes, of the rules.
16, 17, absolutely, Lordship. They can review after 5 years. They don't have power to revoke. Let us see. Because that was supposed to be shown today at the very beginning.
The mining plan, once approved, shall be
procedure for
subject to
approval of
review
the
and
mining plan.
updation at an expiry interval of every year, starting from year, at least 100 days a month.
May I read it, Lordship,
Yes.
one by one? Rule 16. Procedure for approval of the mining plan. The mining plan shall be submitted to the officer specified in clause A of sub-rule 1 under rule 13. Every mining plan submitted for approval under sub-rule 1 shall be accompanied by fees, etc. The Indian Bureau of Mines shall dispose of the application for approval of the mining plan within a period of 90 days. Provided that aforesaid period of 90 days shall be applicable only if the mining plan is complete in all respects. So this is basically 4. The approving authority of the mining plan may, by an order in writing at any time, direct modification of the mining plan or impose such condition in the mining plan as it may consider necessary. It's not happening here. Any person agree by any order made or direction issued in respect of mining plan by an officer of the Indian Bureau of Mines competent to approve mining plans other than the chief controller of mines. The Indian Bureau of Mines may, within 30 days of the communication of such order or direction, apply to the authority to whom the officer is immediately subordinated for revision of the order of direction. That situation is not happening. Provided that any such application will be entertained after a said period of 30 days, not redundant. 6. On receipt of any application for revision under sub-rule 5, the authority shall give the aggrieved person a reasonable opportunity of being heard and may within 3 months confirm, modify, set aside the order. Here also they have not done anything of that sort. Any person aggrieved by an order made by or direction issued by the Chief Controller of Mines, Indian Bureau of Mines, concerning approval of mining plan may within 30 days of the communication of such order or direction apply to the Controller General, Indian Bureau of Mines for a revision of such order or direction. His decision thereon shall be final. Provided that any such application may be entertained after the said period of 30 days, if the applicant satisfies the Controller General, the Indian Bureau of Mines, that he had sufficient cause for not making the application in time. On receipt of an application under sub-rule 7, the controller General Indian Bureau of Mines may confirm, modify, set aside the order. We are not on this. Now, modification of the or review of the mining plan. The mining plan, once approved, shall be subject to review and updation at an interval of every 5 years, starting from the date of execution of the duly executing mining lease deed. At least 180 days, etc. These are absolutely, Lordship. We are not on modification or review of the mining plan here. What he has done, he has revoked the approval. So that authority is not there with him.
What do you say about section 21 of the General Clauses Act?
General Clauses Act, because if the statute has provided a certain way of doing the things and certain
No, the power
action
to,
is not,
power to issue also power to.
that has
announce.
been dealt with by the Madhya Pradesh also. And for that purpose, Lordship, my humble submission is that Madhya Pradesh has answered this question. Paragraph 11.
See, unlike, there has been amendment of the, because the 1957 Act insofar as the mining lease, mining plan is concerned. And this is taken out from the 57 Act.
Mining plan,
Mining plan is given under how is the mining plan prepared? Under what power? It can't be only on the basis of the rules. The power has to be somewhere. Because earlier the state government had the power.
there are two options. One is the mining plan approved by this authority, or a mining plan can also be submitted to the state government.
Yes.
Rule 13. Preparation of the mining plan and system of certification.
Yes.
So what is to be given in the mining plan? Everything is given. Then 14, system to be established by the state government for mining plan. We are not on this. Preparation of the mining plan. And they have done the whole exercise. They have inspected the area. They have given us comments on 84 number of points. We have rectified, and thereafter they have approved it. Beyond their jurisdiction to look into any other aspect, whether this mining and MMDR acts are followed or not.
So this is on the question of jurisdiction and you rely on the Madhya itself.
Absolutely, Lordship. And on top of that, paragraph 11 regarding of the Madhya Pradesh regarding a general clauses part. Paragraph 9, 10. In absence of any power, the impugned order dated becomes unsustainable. However, it is orally contended by the learned counsel for the respondent 1 and 2 that in terms of section 21 of the General Clauses Act 1897, the respondents have the power to issue the impugned order. Section 21 of the General Clauses Act grade is so and so. The Honorable Supreme Court in the case of Chintapurni Medical College and Hospital versus Punjab reported in so and so, while considering that the said contention held in paragraph 26, 27, 32, that when the statutory authority has performed a particular duty under the statute, section 21 of the General Clauses Act has no application and confers no power to review such an act. That the power to review recall could be specifically provided under a particular section under which the power is sought to be exercised. Therefore, section 21 of the General Clauses Act cannot be read to the power of respondents in passing the said order. Therefore, on this ground also, we are of the view that the contention of the respondent of taking aid of section 21 of the General Clauses Act in our considered view will not have any application to the facts of this case, even though various contentions were advanced. So far as the merit of the matter are concerned, we do not think it appropriate to go into the same.
But here he exercised the power under 5(2)(b).
5(2)(b) does not give that power.
Understood? This is the power which
Same.
was exercised here.
Here also, ours also.
5(2)(b).
Yes, 5(2). Ours also same power. He has exercised. Lordship will come to page 207. page 205, first line. In exercise of the power conferred by clause B of subsection 2 of section 5 of the Mines and Mineral Development Regulation Act 19. So same power has been exercised here also. And last line 208. Yes, first paragraph. Last.
No, here he has not exercised. He has exercised
I'll just,
power.
by virtue of the power delegated to me by Gazette notification dated 18/5/2016. I have a notification, that notification I have. In the rejoinder, they have annexed of the IBM.
Hereby remove the approval. No, see
That
the,
notification will clarify.
see the penultimate paragraph, your kind attention is also drawn towards the condition number 6 of the approval, that's so and so. So it is on the basis thereof he has done. You see, here, the order was passed out here by him that I revoke under this. You see what he has done here.
No,
Anyways,
he
Mr.
has
Mi-
exercised his
Mi-
power.
Mr. Sagia,
Lordship.
you take your seat for some time. Let me also grill the other council.
No, but let me clarify this, then Lordship will definitely.
You get a chance. Mr. Sagia, it is not a question. I don't believe in the thing that you are only going to reply on law points. No, I'll give you a chance. Let me get a chance. Yeah.
Lordship will clarify that, why I am submitting that he is exercising this power under 5(2)(b). This notice page 37 of our rejoinder, Lord.
Is a rejoinder?
Rejoinder to the IBM. The pagination is, I don't think it is in continuation. So my affidavit rejoinder to the reply filed by 1 and 2.
Affidavit 1 and 3 and 5. Affidavit to 1 and 2, yes.
Yes.
Page
Page 37.
Ah.
The notification dated 18th May 2016. So he is exercising power under this notification in pursuance of clause B of subsection 2 of section 5 of Mines and Minerals Development Act as amended in so and so and in accordance with the provisions made in rule. Lordship will come to the below one. 18th May, same day.
Actually, that
pursuance
he has
of-
been to exercise the power specified under Rule 16 and 17.
Exactly, Lordship.
His power is not under 5. His
Not-
power is under 16, 17.
First line, Lordship.
Yes. No, that is the power in which he is giving the power.
He is giving the power under 5 to
Five.
act upon 17 and 16. And 17 and 16 does not talk about revocation of the approval. Source is 5, section 5.
No, the power has been conferred, delegated under 5.
Delegated under 5.
And by virtue of Rule 13 of the atomic.
Yes,
Okay, let me hear him. Anything more? Any more judgments? No.
No, we'll let them reply, Lordship. We'll come up.
But, thank you. Because that, why? On 29/1/2021, the mining, grant of mining, this bid was accorded by the state of Arunachal Pradesh. Now that approval which was given by the state of Arunachal Pradesh on 21/1/2021, in contravention to the section 5(2)(b) of Mines and Mineral Development, that MMDR Act 1957, and also in contravention to the rule 710C of the Mineral Concession Rule pilot 2016. Because what is already gone through it now. The 5(2)(b), section 5(2)(b) specifically states that there should be a mining plan. Well, here is that plan is missing. Not mining plan.
They have a mining plan.
Well, that is not approved by the, as per the provision, that was not approved by the authority. It's required to
You
be-
approved the mining plan.
It's required to be approved by the central government.
Is it? Where is it?
Proviso to the 5(2)(b), provided that a mining lease may be granted upon the filing of the mining plan in accordance with the system established by the state government for preparation, clarification, and monitor of such plan with the approval of the central government. Here it is mentioned.
But that is not the reason why you have rejected it.
I'm coming to that one. This plan was annex of E26 on
First
12
of all, who are you? You are a central government?
March.
Central government? You have approved it. Why you are taking
There
up
is a
the
condition given in the that or 12/8/2021 letter. There is a communication, there is annex of E26. There is certain condition is required to be fulfilled. Condition number 6, especially. If the approval conflicts with any other law or court's order, direction under any state law, it shall revoke immediately. Well, here, that amended portion of the rules come into force in 28/3/2021 law. So, in view of this, amendment,
So you say that you have revoked in terms with the mining plan.
this condition already given, that it's required to be, this fulfill the conditions in the 12/8/2021 order. It's specifically mentioned that there are 11 numbers of conditions.
And
The instant matter, we file an affidavit, there clearly states that there is a, instead of straightly come to the, this honorable court, there is a provision under the, statute to refine a bill before the authority. All of these, they are, agree against the revocation of this, that, they ought to have preferred first the, oppose the appellate. That avenue was there, they never opposed the appellate. And
but he is challenging your jurisdiction. If an authority does not have the jurisdiction, can't the writ court exercise the jurisdiction?
Other aspect of the matter is that since without fulfill that condition, the approval was made by the, we have taken steps, annex of R4. Our concerned authority has been suspended. Who issued the approval order? R4 page 34 of the approval order.
So you exercise your jurisdiction on the basis of clause 9 of the approval order. Isn't it? And on the basis of the letter written by the government of India. No, I'm not aware. Annexure R3, page 32. And you say that you are not prepared to do the item number 19. You are not prepared here also. What will happen? Okay, seems that they are not getting anything. Yes, Mr. NNBC.
Like prepares on both.
How did you enter into a lease deed?
While my technician before your lordship is there, I go one by one. Whether 2014 research and prospecting license has been issued was validly made. My humble submission before your lordship is that the state government, without any authority, my lord, that my lord, lease agreement has been, my lord, that lease has been granted. Why I will come, my lord?
Which
Your-
one? The first one.
Past 2014. Lordship can come to the 24 February 2014, is 46. Because my lord, as per judgment of King Nazir and state of imperial of Akira judgment also served. The power has been given in certain way, we have to do that way, otherwise not my lord. But it was not validly made by. You also kindly come to this 24 February. In exercise of power conferred under subsection 1, section 5, mines of mineral, government will grant prospective license for over an area for 3 square meters in favor of complicity for the period of 3 years in accordance with the existing rule and other timing in force. If you also go to the old rule, that is my lord,
1960.
yes, my lord. Act, you also kindly go to the old act, my lord. 1957, it was amended in 2000, subject to correction, my lord. Before 2014, there is no amendment. Subject to correction, my lord. If that is so, my lord, in that specifically stated, my lord, type 2. Have you also got the old act 2000?
Yes.
No lease shall be granted by the state government unless it is satisfied that there is a evidence to show area which lease is applied or has been prospected earlier in existing mineral content. There has been established otherwise than by means of prospecting such area. There is a mining plan duly approved by the central government. Where is that plan? Because state government has no rule, my lord. We have stated our affidavit. We have no rule, my lord. Without any rule, my lord, simply, my lord, a document has been executed, my lord. Under what authority has executed, we do not know, my lord. Such category mines specified by the central government for the development mineral deposit. Proviso has come 2015, my lord. Where is that rule, my lord? Because state government has no rule, my lord.
In the mining lease, we are concerned with prospective mining lease.
I'm
When section 5.1 categorically says about 3 types of leases. One is a recognizance permit.
You are also kind of the heading first. Restriction on the ground of prospective license or mining lease. One has been mentioned that by.
No, kindly listen. When in a statute, the words are being used separately, you have to understand that it will be separately. Now, therefore, 5.1 categorically says that the state government shall not grant a recognized permit for prospecting license or a mining lease. So here, what was being given on 24th of February 2014
Yes, sir.
is a prospecting license, not a mining lease.
Not to my-
Whereas 5.2
Yes, sir.
refers to only a mining lease. Then
That Indian national satisfied that consider as provided in this minor specified schedule for no reconcile permit shall be granted except with the previous approval of the settled group, schedule one, it is a schedule two, my lord.
First schedule.
Schedule, my
We
lord.
are not concerned
Yes, my lord.
because it doesn't
Yes, sir.
fall in the
For the
first.
purpose of section, person shall be deemed to be Indian in the case the other individual, if all the member, from member citizen of India, in case of India only, he is a citizen. No mining list shall be granted unless it is satisfied that there is evidence to show that there is
So
a.
this is a question 5.2 only comes for mining lease, not for prospecting license. This is a 24 to 2014 is a prospecting license. There's a difference between that. I,
Say something different, my lord. My submission is that at that time, state government has. no rule.
rejected that submission.
Yes, my lord.
Now come.
That makes.
Huh?
Next.
Yes.
Your lordship kindly come to that, the prospective license was executed, my lord. Page 50, my lord.
Page 50.
Yeah, my lord. To enter the said land to search for quarrying, boring and digging otherwise link under the throughout the said land. My humble submission as per reconstruction, the survey will be done, my lord. First, they will be done survey. And thereafter, my lord, they will get the, after doing the survey, my lord, they will get the place for mining. For doing the survey, there must be some plan, my lord. I cannot do, my lord. I come, my lord, with some machine, my lord, and boring started being there and there. Where is that plan? That plan is not available. I want to say that, my lord.
No, let me see, kindly see here, section.
Where is that, my plan?
No, that will, I say. What is a prospective license? See the definition.
Yes. Section 3, my lord.
Section 3,
Yes,
G, GA.
GA.
Prospective
Prospective
license
license
means a two-stage concession granted for the purpose of undertaking prospective operations
Operation
followed by
followed
mining
by
operations.
Mining operation.
So this is only for prospective operation. H means operations undertaken for the purpose of exploring, locating, or proving mineral deposit. They are just going to find out where it is only to them. You don't need a mining plan, where it is. Tomorrow, they may have a big machine to find out, okay, there, these deposits are there. And thereafter, they will come up to the you out there and say that, look here, we have found this. Now giving me the mining lease. This is the basis on which it is there.
There is no rule, no plan, no plan has been submitted.
Where is the requirement of a plan for prospective license? Show me that. Are we to insert words?
Yes,
For that, I have to do the
any
election.
concept operation means any operation undertaking for preliminary processing mineral through regional, RTL, geographical survey, geographical mapping, but does not include fencing, drilling.
But
or-
Mr. NNB Chaudhary, tell me why your government has not opened its eyes till now? Why government is writing letters to mines or everybody? You have done, not you, your government have done the mischief, whatever has happened. Why they are not taking corrective measures?
They have
Why it took to in only recent on 8/7/2022 na?
revoke the total.
You revoked it when they got the year of the reply.
Yes, madam.
When you realize so late, on the face of it, you could not have entered into a mining lease
Yes, madam.
deed because of the fact that on the which the petitioner also admits
Yes, madam.
that 29/1/2021 mining lease deed
It's
is
void.
absolutely void
Yes.
because it could not have been. This is in complete violation to date,
Yes.
and it is in terms of section 19 of the 1957 Act.
Yes, madam.
But why? It is your duty to take up out there to forget about the mining lease or not. It is your duty to exercise the power that this has lapsed. Why
We
you
have
have
taken-
not done that?
We have taken corrective measures.
And because of you are not doing, Mr. Goswami's client has been forced to do.
We have taken corrective measure, my lord.
You have been there for the additional advocate general for a long time. Then why this has not happened? Tell me.
Yes, Higher Advocate General is not available.
Yeah, you are the additional advocate general for a long time. And these matters have been pending since long.
Then your lordship may come, my lord. It's order dated 29 January 2021. My learned senior friend has one side argued that this is a mining lease. And another way he has argued that it is only a decision to take mining lease, my lord. If both the way you go, it was, this case is covered under 52B, my lord, because execution was not started, my lord. May I read the 52B, my lord, for letter first, 86, page 86. Grant of mining lease for graphite over an area 4.96 kilometer Taliha, Upper Subansiri district, Arunachal Pradesh. In page 86, my lord. In exercise of power conferred under subsection 2(5) Regulation Act, he hereby grant, the word has been granted by mining lease for graphite over an area over 496 Upper Subansiri district of Steno Cement for the period of 50 years in accordance with the provision of existing rule, subject to in compliance with the said rule made under including Forest Conservation Act. My learned senior friend has submitted because it was on 29 January. Act has come to some in March, 21 March. That is why he should get, my lord, he should not be covered under 52B. My humble submission, his class is totally covered under 52B. 10A to B, my lord. Reason because, my lord, it is only a decision to grant mining lease. No agreement has been executed. Although agreement has been executed, but my learned friend has failed because 710 was not fulfilled. That is why this agreement is null and void, my lord. I also said this agreement is null and void. That if it is null and void, my lord, till date it is a pending case. How can my learned senior friend has said it is not a pending case, my lord?
Or can I rephrase your argument in this manner? That to be a mining lease, if Mr. Saikia said that it is a mining lease, then there was no mining plan at that point.
Yes, my lord. I will come next one. I will.
Okay.
If
I
it is
get
a mining lease, my lord, then where is the mining plan, my lord? Because it is a draft mining plan. It is not certified.
No, not that. Because you see, he got the mining plan later. Document which Mr. Saikia relies upon is
Yes.
of 29/1/2021.
Yes, my lord.
As on 29/1/2021, there was no mining lease.
Yes, my lord.
If there was no mining lease,
Yes, my lord.
there was no mining plan. If there was no mining plan at all, there could not have been a mining lease.
Yes, my lord.
And as such, that document under no circumstances can be construed to be a mining lease.
Yes, my lord.
And if it is not a mining lease, then he comes within the midship of the proviso to section 10 to
Yes. Yes, my lord. And another thing is that, my lord, 10 to B, because my lord, 5 to B, my lord, also kindly read.
But why are you not doing anything? What? You have the habit of putting the gun in Mr. Goswami's shoulder and shooting. Otherwise, what?
This is my best friend, my lord. Yes.
But why you are not doing? Why the government of Arunachal should be doing it? They are frustrated with the government of Arunachal. That is why Mr. Goswami's client had to do it.
Subsequently, they have taken corrective measure, my lord. We have revoked all these things, my lord. And when we revoked subsequently, section 4 was not followed, then your lordship has set aside the matter and matter has been sent to for hearing, my lord. I told secretary, because they are hearing part.
But what you set aside there?
Because.
No, tell me, no, here, it must be here somewhere, that document. 8/7/2022 must be here because they came to learn only here.
4/7/2024, that is the letter, my lord. In, yes, my lord.
No, it was done in 2022. Where is it? Where is your reply initially? They could
Yes, yes,
come
my lord.
only to learn
It
from your
was sent in
rejoinder.
audio,
Because that was the basis on which
Yes, ma'am.
they came after
14
2
July
years.
2022. Cancellation of provisional mining list in the graphite over area 0.7. There has been reference to
Where is that document?
that document in other case. I got it.
No, it's very difficult. Because they say they came to know from here, na? How did you come to know, Mr. Sharma?
There, I filed that affidavit, my lords, will be called.
You you say your cause of action in those matters where
That
that
is- that is the
you
other-
say that some affidavit was filed here and as
affidavit is
such.
not-
Somewhere, something, some problem.
First, yes,
But the document was not annexed. It was only a word as an averment in the affidavit in office.
Then affidavit in opposition, where? You have the copy of them?
22. Delegate of Hyderabad, delegate of Hyderabad. This is the order.
So now, as of today, what actions you are taking by each deal?
Yes, ma'am.
And they have taken the pains of challenging. They themselves are arguing today that a provisional mining lease deed dated 29/1/2021 is non-est. So if I record that submission, your proceedings there goes for a 6, means nothing happened, finished. Means that their own submission. What did you cancel? That is why I wanted to ask. Because their specific submission today, as I could see, is that the mining lease deed. There's a difference. Here you cancel the mining lease deed. Mining lease deed could not have been issued because it would have been, it was in violation to 710. So they say that this could not have been done. They asked at the stage of a grant of a mining lease. That is the submission. So then what was wrong with this order? In view of their submissions now, don't they themselves admit?
Admit that this list is not
Have
available.
you mentioned anything in your pleadings about this very aspect of the matter which Mr. Seke is arguing? Because this is completely contrary to what is happening.
My lord, it's irregular. In the pleading, we have said it is irregularly. That we have said. Because my lord, with this particular, the lease, mining lease deed which was executed, it has certain condition precedents. So what we say is that those conditions have to be, in order for me to carry out the mining operations, I have to fulfill those conditions which are described in the mining lease which was already executed, the deed that has been.
So therefore, the mining lease deed could it have been possible
Say it was
in view of what your submission? Let us not mince our words in saying what is what. Because from day before yesterday till today, what I have been hearing is that this mining lease deed, which was executed, was non-est. It couldn't have been done because there has not been a compliance to A, B, C. C came only pursuant to 29/1/2021.
Say, my lord, that the lease deed that was executed, that also contains all the requirements which are prescribed in 7. In rule 710, whatever are the requirements.
You see, whether there is a concept of a prospecting or what is the use you use
Provisional,
a provisional? Is there any concept of a provisional mine? So that is completely foreign. So it has to be either we have to follow the rules. So the concept of
So
having a
therefore, what my lord
provisional mining lease is not there.
Therefore-
Deed is not there. Whereas, what is your submission is that the mining lease which was granted on 29 by the whatever official of the state of Arunachal Pradesh is the very deed, is the mining lease itself.
And senior friend is arguing the points, so I don't want to overstep that. The distinction that we are trying to draw today is, the distinction is that one is the grant of the mining lease, and the second aspect is the execution of the mining lease deed.
That is what I am saying. The earlier round of litigations which have culminated,
That is on the mining lease deed.
deed, that is what.
Well, yes,
But here, therefore, now you are therefore submitting,
Right.
which I have now remitted back.
my lord, has-
Your very submission is this could not have been at all executed because there has been no compliance to 710. Isn't that the submission?
that issue, my respectful submission does not arise in this
No,
particular.
no. I have to take note of, I have to record that submission.
My lord, our case has always been that
Then what
particular.
remains in that hearing? What remains in that hearing? Because that was what was cancelled as per 14.7.
Our case regarding that particular lease deed was that particular lease deed contains certain conditions. So we are saying that it was irregularly executed because there is no concept as such of a provisional mining lease deed. So we say, but then we also say.
Are you only saying on the question of concept? Or are you saying on the concern on the question of 710 not being followed?
Hello.
Let us understand that. That is a very important aspect, which again, if you are saying that it is irregular, that means it is not illegal or non-honest, which means it is yet to be executed. If I hold that that is a requirement, and then 710 is to be followed,
Yes.
then your submission which is there, that 76A having been complied,
Yes.
it takes care of the proviso,
Yes.
will go.
That is a step subsequent to that. As my learned senior friend is arguing that. That is a step subsequent. Please. My lord, my learned senior friend has already, my lord, placed that for my lord's consideration. My lord, our submission regarding my lords have put a pointed question. I'm trying to put it in perspective. The mining lease deed which has been executed, in this case, which was cancelled and my lords have demanded the matter back. If my lord sees the conditions.
No.
prescribed
They
in
first
that-
of all, that could not have been executed as per 710. Could it have been?
Yes, it would not happen. If my lords are putting to me that.
That is the
pointed
answer.
question,
Now, that is in the pleadings? That is my question.
But my lords,
Is that
the
in
issue
your
of,
pleading? Because that is the basis on which he is saying.
my lords, but the issue in this case is only whether I have a grant of the mining lease, the execution of the mining lease.
We
though
will-
irregular. in the
I
second
know what
case.
is the issue, Mr. Sharma. I know what is the issue, but the question is here as regards whether is it indeed pleading that 710 having not been followed.
Yes.
The lease deed is not there.
Yes,
Means it could not have been issued.
it,
Is
yes.
that anywhere in your pleadings? That is what I am my question.
my lord, in our petition, in this present petition,
No, you have thereafter filed reply.
Our case is very simple.
That
We are not on the issue of the deed. We are on the issue of the mining plan.
is what I am saying.
We are purely because by the impugned order, our mining plan approval has been revoked. So whether that action is legal or illegal, that has to be examined. The other issue, Lordship, on the
because
principle of
your-
natural
your
justice,
Submission effectively that the grant of a mining lease by an order is sufficient to constitute it to be a mining lease.
yeah,
There is
that is one
no,
issue.
there is no requirement of execution of a formal lease to come within the mischief of the proviso. That is your
Absolutely. That is,
Absolutely.
I fully agree, and this is the core question.
No, but to say so, I'm just asking the councils who were appearing here,
The other case,
because they were appearing, no?
yes.
And there. This was the order which was, passed. You may not be aware, 1470. This was challenged. The rejection was challenged on this, that could not have been done and all this thing. But now your submission which is there, that this lease deed could not have been at all executed.
Yes. Now, my submission would be very clear. The earlier round of litigation, whatever it may be, it was basically revolving around the mining lease deed. Now we are not on that. We are on whether a pending application will govern a grant of mining lease, or it will also govern grant of mining lease plus execution of mining lease deed. That is the area. And in the other case, the issue was not regarding the mining plan.
There was the cancellation because of the no mining plan. See,
Cancellation of no
the
mining
lease
plan.
deed,
But now we are
not the grant,
grant.
but the lease deed, which you now
But in any
submitted,
case,
yes, it could
now,
not have been.
now the present case is the third concept, that whether the mining plan has been rightly revoked or not. That is the question. For that, whether mining lease is there or not, that will be a different issue.
Isn't it your submission?
But mining lease.
No,
mining-
if I am to record your submission,
Yeah, I Lordship will definitely record my submission, because when I will sum up, Lordship will definitely record it. My submission is, Lordship, that for grant of mining lease, sorry, for grant of mining plan, whether mining lease is required or not, that is not the issue. And that is not a prerequisite also.
so are you saying that the grant of mining lease is the horse, means for that, there is no requirement of a mining plan? If it is so, would
No,
that
no,
be a
that
mining
it is
lease?
reversed. For grant of mining plan, grant of this mining lease deed is not a prerequisite. Sine qua non. So for the mining plan, Lordship, that lease is not a mandatory condition that I have to be fulfilled.
I understand that your submission to that, but I'm asking if whether there is pleadings out here to that effect, that 710 having not been complied with, the lease deed could not have been executed.
Lordship, we have the pleadings, let him complete and we'll give our.
Only that, where is the
Yes,
pleading?
in the rejoinder, rejoinder to the state, paragraph 8 and 9.
Rejoinder to whose?
State, the state, my lord, my learned good friend, Mr. Tomu.
Paragraph?
Paragraph 8. It is telling that the state in its narration of facts, in its reply has omitted the document granting the petitioner the mining lease annexure so and so, as it is by virtue of this grant that the petitioner is entitled to protection from 2021 amendment. The grant itself is not subject to the fulfillment of any statutory clearances and is unconditional and is evident from the cursory reading of the document. The state has averred that as a duly approved mining plan had not been submitted, the erroneously granted provisional mining lease was bad in law and thus null and void. It is already been established herein above that as per a unified reading of the act and the rules, a approved mining plan is not required for grant of the mining lease under Rule 7(6) of the MCR 2016. It is only before execution of the deed that an approved mining plan is required. In the present case,
The line, no?
reiteration. Paragraph 17, Lordship.
Yeah.
It is true that the execution of the conditional mining lease it was not in conformity with the provisions of 710C of the MCA 2016, as it was conditional. it is not the petitioner's case that it can mine today. The petitioner will only be able to mine once all the conditions in Rule 710C have been complied with.
Yes,
See, what's the kind of look?
710C is that one, 5B. Mining plan as per 52B.
To a mining place specified in clause B to section 52B. Then your lordship kindly come to the 52B, my lord.
Again,
Yes, my lord. Because my humble submission before your lordship,
52B, you need not, I have, yes, tell me.
the thing is that, my lord, before, my lord, if he said this is the mining list final language, mining plan must be there, my lord. Without mining plan, my lord, that cannot be done, my lord.
That
the
cannot be construed to be a mining lease.
mining
And
list.
if it is not there, so the mitzvah is there.
Yes, ma'am.
That is okay.
Yes,
How do you take care of the jurisdiction?
jurisdiction part, he will say this.
No, he has not stated in, he only says about clause 9. The fact is, the question would
My-
have,
because
the
your lordship kindly
action
come
would
to
have, ought to have been taken by the state.
Yes, yeah, yes, my lord. Yes, I'm coming, my lord, on that point, my lord.
Why it
Jurisdiction.
is not done by the state, but it is being, they had to do it. And they had to do it because one person had to be suspended.
Yes, my lord. May I read, my lord, grant of mining list in exercise of power, section 52 of the Mines and Mineral Development, you have a grant mining list for graphite, stand of so and so condition. The grant is subject to the following condition. That mining leaseholder shall obtain environmental clearance from the state government, state environmental impact, or from the government of India. And COVID non-forest, then the consent from the community and local landowner. The mining leaseholder shall also obtain consent, approval, permit, no objection as may be required under applicable for the concern authority. Shall provide performance security, not necessarily mine development protection. not
What are you reading?
Page 87.
No, we are not concerned with that. We are concerned with 205.
So one order, my lord. Why it is necessary, my lord? Approval. Your lordship, kindly come to the on the 178, my lord. Yes, my lord. Two zero five, my lord. Sorry.
Yes, that is what I was showing you.
Yes, my lord. I am coming one point, my lord.
Yes.
Point number 1. Approval for mining plan, mine closure, there is idea. In exercise of the power sensor, their mining plan is approved without prejudicing any other law applicable of the mine area, whether made by the state standard government or state government or any other authority without prejudice or direction from any code of competent jurisdiction. Let them show the mining plan, my lord, which has been approved by the state government. State government cannot be done. There is no rule for certification of TPS. Nothing is there, my lord. How can they approve?
Who?
State government. So
This is approved by the government of India.
next point I am coming, my lord. Government of India has said, my lord, that they are not approved these things, my lord. The mining plan is approved without prejudice to the law applicable to the mine, and to whether made central government, state government, or without prejudice to the order and direction of the competent jurisdiction. So state government has jurisdiction, my dear. Central government has jurisdiction. The approval of mining plan. If that is so, my lord, he has got the jurisdiction. In jurisdictional part.
This is being done by the government of India.
Well, government of India, he has said no jurisdiction in that part. I'll learn senior finance said.
Hmm.
Person in India. That is the jurisdiction point, my lord.
The mining plan is approved without prejudice to any other law applicable to mine area, for the time being, whether made by the central government, state government, or any other authority, and without prejudice to any other order or direction from any court or competent authority.
There has no minor rule. It has to be approved by the central government. And if it is central government approved, my lord, then jurisdiction will come, my lord.
Understood,
Yes, my lord.
but why are you cancelling it? Why is they cancelling it? It is the duty of the state of Arunachal Pradesh. That is what his submission is. It could have at best be done by the state of Arunachal Pradesh. But you are the person who is giving it. It is not given by these people. They are only giving a minor plan.
Well, that my instance. That has been ordered as the revocation order has been.
Huh?
That revocation of the subsequently 2022 that has been passed.
Oh, that 14.7. But that is only for the prospecting mining lease. Deed.
Next, you also come to 0.6 minus. 206. If this approval conflict with any other law or code or direction under any statute, it should be revoked immediately. When there is no mining plan, my humble submission before your lordship, then the final, they cannot issue the final mining list, which has been submitted by my lord, senior player, grant of this my lord. If that is so, my lord, under using the exercising the power
They
section,
had the mining plan. This is the mining plan. This is the approval is the mining plan
the mining plan by whom?
by Government of India.
Government of India, my lord. And subsequently, Government of India has said that this was my lord without any authority of law. He has approved this mining plan.
That is the impugned order, which I am to adjudicate.
Yes, sir.
But the question is, therefore the question is, mining plan is there.
That is here, my lord.
Hmm.
Where it was submitted, mining plan, my lord? It was submitted on my lord. Hello. Huh? Twenty-five 1/2021.
Mining plan was subsequently made. Your letter received on 26/2/2021. Ah, 26/2/2021.
Yes, sir. And when it was issued, 15/1/2021. In a grant of this manner, 20. What? What is it? 29/1/2000. Subsequently, mining plan was submitted. And
Anything more?
anything more, my lord, I have stated, my lord, that the central government has jurisdiction to interfere into the matter, my lord. If that is so, under section 16(5), there is a appeal provision, my lord. If they can file an appeal, that appeal was not filed. And there is not mentioned why appeal was not filed. And in respect of jurisdiction of the central government, that was not challenged in the petition. So, if there is an appellate provision, my lord, there is an alternative remedy, my lord, they can go to there, my lord. Other submission I have already submitted, my lord, in my written.
You will give a written submission. 16.5, what is this?
16(5) also.
The made or direction issued in respect of mining. Into the mining.
And another thing is that, my lord, my humble submission before your lordship is that, my lord. My lord, they cannot approve it, re-approve it same time. When they, in other cases, they were stated, my lord, this mining, this has irregularly, my lord, executed. Now, in this case, my lord, they have stated. So, firstly, this case was filed. Subsequently, that case was filed, my lord. What is the stand? You cannot approve it, re-approve it at the same time, my lord. That is my submission, my lord. You have to take one step.
When did they reappropriate?
My humble submission before your lord.
Yeah, they are appropriating. This is the first litigation. Reappropriating in the second.
Secondly, so. 16.5 said. Page 80.
Okay, okay. We'll hear you, your reply today.
Some other day, Lord.
Okay, when? Next
Monday.
Tuesday?
Monday.
Next Monday?
We'll give a short writings also, whatever our submission.
Monday, we can have it on Tuesday.
Tuesday, Lord.
The Monday it would be difficult there,
Not-
there are other matters. Okay, hearing remains inconclusive, list the matter again on Tuesday. Or at the top of the list, top of the list, sorry,
On Tuesday, Lord. Thursday.
Tuesday.
Lord, say, could it be on Thursday because one of my friends is having some. Could it be on Thursday next?
Thursday, I'm not available in the school.
Let it be on
Just like here, you were
Tuesday.
there.
We'll manage.
You see, the
We'll
problem is getting you. Not the other. The others are very,
Got
can be easily available.
We'll submit a raw short written submission.
Tuesday or Thursday.
Tuesday.
Kindly.
What is the matter about?
Yes.
Yes, very good board. Respond now, sir.
We have closed it. The petitioner has left it.
Yes, ma'am.
He's not functioning.
Most probably, madam, he has shifted to another place because he has not come in the last occasion, madam. Even on the last occasion, madam, there was no representation from their side.
Who is there in the, for the petitioner?
Name of I Hussein is reflected.
None appears on behalf of the petitioner on call. The case of the petitioner hearing is that the petitioner was running a mutton and chicken shop. In a room owned and possessed by him. The case of the in the month of October 2018, certain antisocial elements had obstructed his business. And in that regard, the petitioner had submitted a letter to the additional district magistrate. And in that regard, he made representations to the respondent authorities to maintain law and order. It is the further case of the petitioner that the Rangapara Town Committee mostly illegally shut down his shop on 21/10/2018 without any notice. Further to that, it is also the case of the petitioner that he had submitted various representations which have gone unheard. And as such, the petitioner has approached this court. You've seen that the pursuant to a notice issued by this court, an affidavit has been filed by the respondent number 5, wherein it has been mentioned that the petitioner was running his business of mutton and chicken shop without maintaining proper hygiene. In addition to that, there were various complaints as the petitioner kept his wastage as well as dirty water in the open. Further to that, on account of various law and order situation prevailing, on 25/10/2018, in presence of all the parties, which included the mutton shop and chicken shop owners, a meeting was held and it was agreed to that the mutton shop and the chicken shops will remain in place with effect from 25/10/2018 to 4/11/2018. It was also agreed that on 5/11/2018, all mutton shop and chicken shops will be shifted to the original shed situated inside the daily market provided by the Rangapara Town Committee. It is also mentioned that in pursuance thereto, some of the mutton and chicken shops were shifted to the said market share provided by the town committee. But the petitioner did not shift. Rather, he closed the shop. From the materials on record, it therefore transpires that that on account of public interest and in view of an agreement, the shop of the petitioner was closed down. And the petitioner was permitted to carry out his business inside the township. Because under such circumstances, the question of exercising the powers under Article 2 to 6 of the Constitution does not arise in the facts for which the writ petition stands dismissed.
Item 27 to 66, part third.
Yes, Mr. Barbaria, what to do?
Now, here is all the matters. Except one matter, that maybe my lord item should be item 66. In all other matters, notices have been issued by the authority. Of course, my lord, that notice was issued, my lord, to asking the person concerned to vacate. Now, post Salakuddin, your lordship has held that the notice
Why 66 not done?
66,
Why in 66 it was not done?
66, my lord, it has been filed apprehending, my lord, eviction. 66, petitioner apprehends eviction.
So he has not received till
Yes,
now.
sir.
He have not issued notice. But he is in government land.
Admittedly, everybody is in government.
Then why are you not issuing notice to him?
Before issuance of notice, my lord, he is apprehending. He is apprehensive.
When did you issue notice? Earlier.
Huh?
First you issued notice,
Yes.
then they approached.
Because consequently, all these matters, my lord, pertain to the year 2022. All these petitions pertain to the year 2022.
What is the number of 66?
66 would be, my lord, WPC 2174 of 2024.
So in all other matters,
My lord,
in all other matters, notice have been issued.
that is the admitted position. Notices have been issued. They are residing, my lord, in certain parcels of land which are reserved for TB hospital. Now it is, my lord, the second medical college in Guwahati. And in some of the matters, my lord, the exercise has went to the level of almost giving them settlement. And it was done on the basis of, my lord, primarily on the basis of the report, my lord, furnished by the circle officer to the office of the deputy commissioner, and the deputy commissioner makes a communication seeking, my lord, approval from the government for giving settlement to some of the petitioners in this writ petition.
But no settlement has been
No
done.
settlement has been done, and my lord, we have filed now additional affidavit. Now, lordship will find here in all these matters except this new one, my lord. In all these matters, we have filed affidavits. Affidavits have been filed in all the death cases, and there we have taken a, my lord, common stand that, my lord, these part and parcels of land are, my lord, allotted in the name of, my lord, TB hospital, my lord, which is now the second medical college. And there are, my lord, documents on record to show, my lord, that the SDLSC has taken a decision, my lord, that the nomenclature of the land, of course, we have annexed the Chithat. There it is shown as TB hospital. Now it is changed to second medical college.
But nonetheless, my lord, admitted position is there, my lord. They are occupying government land, government trust land. Now, government trust land and big notices were issued way back in the year 2022. Some notices were issued in the year 2023, thereby asking the persons concerned,
What is this government custling?
my lord,
What do you mean by government custling?
other than my lord, media land or roadside land. Other than media land or roadside land.
It. So, where is it mentioned anywhere?
Wasteland. That is government wasteland.
Are you therefore saying government custling is wasteland?
Most of the cases, my lord, it pertains to the, it pertains to the character of my lord wasteland.
Because it's some land and revenue regulation. Nowhere says about custling.
Yes. It is silent.
Even in the definition of, in the
Wasteland.
settlement rules also, there is no custling.
Yeah.
But you have used the custling being more influenced from West Bengal. Otherwise, there is no custling. Custling means in Bengali, government. You don't need to use government.
Government husband. Husband means yes.
Means custling means government. It is something like the true facts of the case. There cannot be a true facts of the case because the facts means true.
But then normally, my lord, we say that, I mean, finally, some sort of documents, so that we, for recovery of.
This is going on because that has been going on for years, ages. Ask me the age. Common parlance and putting it is out there in the rule 18 is a different.
No, 18 doesn't.
No, 18 says. See 18(2). When you made the amendment in 1997, you put the word government trust.
Government husband.
That is why I mentioned it out there in my Salaguddin. Yes, Mr. Dhar. I've been spoiling time out here unnecessarily. I'm just waiting for you. Where will you appear? Now you go and show it before the deputy commissioner. File your representation showing it that you have a bona fide claim of right in law. Why should we go decide on this?
We will furnish a list to Lordship, because Lordship will be passing a common order.
I'm passing an order now. Yes, tell me, what is the list?
Some of the matters, my lord, where settlement has almost been, my lord, done, but we are now
Have
recalling.
you issued the allotment letter?
Not
In two cases, patta has been issued. In two cases, patta has been issued.
Which are the?
They are not the petitioner hearing.
No, it is not here, no. We're not concerned with here. I'm here only to the effect that whether in any of these cases, allotment letters have been issued.
In two cases, Lord.
Allotment letters.
Allotment order has not been issued, but to realize the premium. Three cases.
on to that level,
One
now
is-
we have recalled.
For realize the premium is on the basis of an allotment order.
Yes,
Has the allotment order been passed?
by the government.
Where? In which petitions? And what list have you prepared? If I remember correctly, those are not here. You are alleging that some other persons have been given,
Yes,
and as such, why not you?
yes. And in
And
one of the
those two
cases,
persons are not here.
in one of the
Then I
cases,
put
Sunil
a que-
Rajak.
Then I put a question to them. Why have you done all these things?
Yes,
Isn't it the case?
yes. Lord.
They are not here.
No, Sunil Rajak, from whom the already the amount has been realized by the government.
He is the
The
petitioner
premium.
here.
Yes, yes.
Which one?
Sunil Razak, item
WBC number? Item number?
Mr. B. Sheila is appearing. Earlier, you were appearing, but subsequently the brief was taken by.
Synopsis, my lord. This is synopsis of the entire, my lord,
The amount of cases 30, 30, 30, 30.
Item number 30, my lord.
This H, Arun Singh, Arun Kumar Singh and
Yes,
Sel
sir.
Devi.
Shell Devi.
We have categorized them as special category cases. Your lordship will find the repetition numbers, my lord. Of course, my lord, the items, because it has been listed for several occasions. But nonetheless, we have mentioned the repetition numbers. And so far as my lord, fragmentation of land is concerned, my lord, this basically falls under my lord 4 DAG. DAG 96, 97, 201 and 202.
And what are the special cases you have put at 8, 9 and 10 page? Page 8, 9 and 10 of your synopsis. What are why these are special cases?
But almost. But it has
No,
not been
no,
done.
kindly see, Sunil Raja, petitioner had deposited the premium. But you have not refunded, you still hold it,
Hold it.
but the patta has not been given.
This is the case lordship will find because that was done acting on the basis of the circle officer's report. Later on, we find, of course, during the pendency of this proceeding, we found that the circle officer's report was a faulty report. It was not based on the correct factual situation. So we recall that circle officer's report, and circle officer has now furnished a fresh report whereby there is a proposal, there is a request for cancellation of that allotment. So, that was done in favor of that person. Accordingly, on the strength of that circle officer's report, the deputy commissioner has acted now to request the government for cancellation of that allotment and refunding of that premium. Because it was done on certain misconception of tax. Because everything is the genesis is the circle officer's report. Because he is the authority, first authority on field to make an
What
inquiry.
about Arun Kumar Singh?
Arun Kumar Singh, same. The lordship will find in each of those petitions, we have filed affidavit as well as additional affidavit.
No,
We-
what about Shale? Because Shale is this one, Hamida Khatun.
Yes.
The government has queried regarding remark column of Chita, which is marked as so and so photograph showing the full house and the proposed plot, documentary of indigenous of the petitioner. Thereafter, the office of the Imam had submitted a report as sought for, but the office of the district committee had submitted a clarification that the report submitted earlier to be considered unacceptable as the matter is related to TBOs. So in these items, there is more particularly 7383 and 7384.
Sunil Raja, Arun Kumar Singh, Shahid Devi.
7389 and
Yes.
7399, there is nothing, there is no report allotment.
There is no allotment, but a move was made, an exercise.
The
was-
move was made,
Yes.
but process was initiated,
Process
but
was
nothing
initiated.
happened. But
Yes,
the
yes.
process, but something happened in these matters. Sale Devi, Hamida Khatun, Sunil Rajak, and Arun Kumar Singh.
Non-commercial.
So here, In one case, premium has been deposited, others premium has not.
Now, we have filed additional affidavit hereby bringing on record that now the authorities have undertaken an exercise for recalling that earlier all pilot, the exercise. Circle officer's report has also been recalled. And a fresh circle officer report, has been minor sought for, which has also been annexed minor to the additional affidavit. In this writ petition. That is the only distinction
Now,
factor.
tell me another thing.
Yes.
Now, DC has already given a report.
He has already given a report, yes.
Would it make any sense for them to go into before the DC can submit a representation? Taking into account that the DC is already influenced now. Would it not amount to sending the petitioners from here to the guillotine?
Because, Manoj, if we, Manoj, make a strict connotation of, the dictums going in from Salahuddin, then Manoj, Lordship has held Manoj the issue of bona fide claim only to that extent. Because, they are safeguarded to the extent, Manoj, that
Because
they are-
there are two ways. One is Rule 18. One is Rule 18.
yes.
The other is under that act. What do you call it?
Then they will check Manoj, perhaps Manoj, then they will check. There are two elements, one, first of all, that civil proceedings have to be drawn up, then the criminal part, if they have found.
Criminal is different. We are not concerned with criminal. Criminal will happen later on. First is the civil,
Therefore,
then the criminal.
no, if that act itself envisages a situation, if a application is made before the special court, special tribunal, then under section 10, then there are two facets of that proceedings, First, the court down below will take a call on the question of whether they have a title or bona fide interest or whatever it is, the civil consequences. Then, upon the findings that may be arrived at, in the preliminary part of that proceeding, the whole proceeding, then, if it is found that yes, there are lapses, it is prima facie found.
No, not privacy. That amounts to a decree, guys.
Hello?
That amounts to a decree.
Yes, that amounts to a decree.
So it is no prima facie.
Yes.
The
so that
moment it comes to a finding that they have no right. You see, there is a difference. In a land grabbing proceeding, the burden is not on the state. Initial burden is on the state to show that this is it. For them to prove that yes, we are in this, we have here they have to show a better right. Not a bona fide claim of right involved, but he has to show a better right to remain.
almost it as a quasi-civil suit. Almost. To that
Yeah,
extent.
but the right which is being given or the declaration which is being given amounts to a decree.
Yes, it amounts to a decree. Then on the strength of that, first preliminary proceeding when the civil, the civil consequences are determined, then the next stage, the criminal part is taken up.
Criminal is okay, that can follow. But first the civil is there.
Then
And
the
if once
difficulty-
that is being done, the next stage is criminal happens. The only way is to come here under 227.
Therefore, 27, but then again, the decree has to be put to execution, it will be a exercise. But Salahuddin, if we go by I'm making a submission, if we go by Salahuddin, then the deputy commissioner will limit himself only, whether they have raised a bona fide claim. Bona fide claim,
Monopoly claim or right involved.
right?
No. There's a very marked difference. That is what problem happened in 86. when those judgments were given in the context of a bona fide claim. Bona fide claim means whether there is a bona fide dispute.
That bona fide, I have to have a bona fide claim so that I establish my right. Bona fide claim to establish my right or a semblance of right, whatever it is. Now, it can only happen, my lord, that 84, my lord, division bench decision, my lord, I have forgotten. There, my lord, division bench of the honorable court has taken a clue that there was a prolonged, my lord, long duration of, my lord, occupation. That itself may give a right, my lord, to give a right of, my lord, bona fide claim. That decision, my lord. Now, prolonged occupation, that is one aspect of the matter. Whether permanent structures have been raised, that is another aspect of the matter. These are, my lord, some facets which will give rise, my lord, to a bona fide claim of right involved. So therefore, my submission would be, my lord, subject to what lordship says. If you go by Salakuddin, then, my lord, matter is delegated to the deputy commissioner. The procedure, post decision of this honorable court, matter is delegated to the deputy commissioner. They will find individual representation. They will be given individual right of hearing. Deputy commissioner will pass speaking order. Just like in those, my lord, Sonapur eviction matters lordship has dealt with, my lord. Then if they are aggrieved, they have their images under the regulation. So that will be an order available. Any order passed by the deputy commissioner. So ultimately, that
But
will,
the deputy commissioner will only decide one aspect as to whether there is a bona fide claim of right.
that much.
That's it.
Then we will be safe. State will, well, the time, energy and resources, my submission. Because if we go down before the, my lord, special tribunal and under the land grabbing act, then again, my lord, the execution of decree will arise. Maybe, my lord, we may have a decree, but we have to put the decree to execution. That will take again years. There will be persons on the,
Who will execute the decree?
my lord.
In a civil decree, who executes the decree?
People that
That is understood, but through whom? Police is yours. The revenue is yours.
and again, we will save some time. At the end of
But
the day, we will save.
why I'm saying, at the end of the day, all these litigations which will ensue from here, the moment I send it from here, there, and then from there to there, and go and come again here, and then division bench. So there might be 1, 2, 3, 4. 4 rounds of litigation prospective.
Yes, yes.
Whereas in the other case, 1, 2, Supreme Court is 3. Isn't it? And if I put there, Supreme Court is 5.
Supreme Court is 5. But then again, my lord, from the decision of the.
And there is a chance in the second one, I mean in the first one, if this court again holds in 226, because from Board of Revenue it will come under 226. If this court holds, yes, there is a bona fide claim of right involved, then I can.
Yes, it will be a continuation.
Then you again go to the second option from 1. Tell me. Now, that is why I actually think. Otherwise, for me, it's 2 minutes of the. They would love to go there. That is why Mr. Dhar is very happy, smiling. But the fact that the moment you go there, he knows from 1 to 2 to 3, 4.
Ultimately, an available order, of course, my lord. That is.
And moment the question comes for eviction, the court also gets lenient enough. Now I have now become very lenient for GMC matters. I have become very lenient in GMC, but not for till now. I have not lost trust in the revenue till now. The moment I lose, then I'll also become lenient. So by the time when this stage it comes, after 4 stages I come here, I may become lenient.
Now. Of course, my lord, if you go by the land grabbing procedure, my lord, there it will be a decree. And now, what is going to say, the,
I am saying there are certain cases. Here it is a case of wasteland. You have now brought them within the purview, that land within the purview of earlier TB hospitals.
Earlier TB hospital was also, it was not allocated to the TB hospital. This is the deputy commissioner report to the government.
When was it allocated to
Recall,
TB?
it was not allotted, never allotted law. So this is the deputy commissioner has written on 3/1/2022 to the commissioner secretary government of Assam revenue and business.
yes, which now we have recalled. He is relying on the idea. He is not relying on the.
I'm saying about the TB. When was it brought in the Chita as TB?
It is the crux of the.
Always, my lord. It
No,
is-
then it will come within there are 4 categories. The first is those lands which are, what lands are they? The 4 categories of land.
Arun Kumar Singh, I have a next step. Letter one.
No. As per,
Yes, my lord, said that.
what are the 4 categories of land?
Yes, my lord, one is the roadside land,
2,
Yes. who will be my lord VCR. Then he will be my lord reserved for public purposes.
yeah, there.
Yeah.
So, whether TB hospital was brought in.
Yes, it has been reserved for public. It goes, the Sikha goes to so.
No, not now. Now you're making it second. This is happened now. I'm asking you whether it was reserved for public purpose. Because then, you see, then the question comes, there cannot be a settlement. If you see my Salakuddin judgment, there cannot be a settlement if it was reserved for public purpose.
Now the Sikha which we have enclosed, my lord, which we have annexed along with our affidavit, that goes to show, my lord, in the remark column, Motoibo, TB Sikikhala.
When Chita of which year?
My lord, it is. Date is not here.
Not they, which period?
Yeah, my lord. They expect the Sikha, but it is precisely not here, my lord.
Anyway, you'll take a call. So you want the first of.
Let them produce the entire records without.
These matters have to finish today. The order has to be dictated before 3:30 and finished.
Since Lordship has been, my lord, could I extend, my lord, whether you can go for, my lord, the.
That is what I asked you. Think about this. This is a very important thing. At the end of the day, you may win the battle, but lose the war. Because these people are having houses.
And I'm deeply obliged, but with Lordship's, my lord, kind connotation. If Lordship.
These matters were with me long time back. The matter went from me long time back when I sent it to the division bench. Thereafter, matter never happened. So you may get a similar fate when the 4th round counts here. Remember that, which has a far-reaching consequences. On the other hand, here we are only 3. 1, 2, and then Supreme Court 3.
That extent if Lordship gives me some accommodation, let me take the instructions, my lord.
That is what I was asking your Advocate General also. What do you want actually? I have no problem out here giving it, because what I am trying to say is that, okay, let him go and submit. The moment they submit, and so that yes, I have a bona fide claim right to know.
Because even if the deputy commissioner might not negates their board of study, it will be put to appeal my lord before the board of regents. Continuation, it's a continuation. Then comes to 26, then comes division bench, then my lord SLP. No, no, I'm grateful.
And not only that, in the meantime, the government gets frustrated and okay, now we'll go for the second option.
They try to inculcate it in a judicial.
And in the meantime, lot of people die. Will happen. With the people dying, what the next consequences is substitution.
Matter, it is always a catch-22 situation for us.
It's not a catch-22. I am giving you the option to that matter. I gave you that option then also. That this is the only way out. And then Mr. Dhar again comes up, taking the clue out there, which I kept it open in the Salakund days.
He has got enough clue today, my lord.
Eh?
He has got enough of clue from my lord today. He will now.
I'm over.
We are always grateful to my lord. You know, people kindly, my lord, accommodate me for a short time, my lord. Maybe my lord next week immediately, my lord. On Tuesday.
Or you do one thing.
Let me get the instruction.
No, let me remand it. I don't want to decide whether they have a bona fide claim or right. Because this will again put a wrong precedent.
Not deciding it.
No, I'm saying. For putting you to the second option, I have to decide.
Yes.
I don't want to decide. Let it go. Take a call from the decision. Whether you want, in view of that decision, what do you want? Should you go there? It will be another 45 days. Let them submit their representation. I think that is the best.
From Salahuddin, my lord.
No,
Because
that would be the best way. Because if I start holding out here that they have a bona fide decline or right involved or anything, it will again create another problem later, and it will be a precedent.
So, because, yes, the reason being, my lord, these are two separate legislations. Reason being, these are two separate legislations. One is, my lord, 2010 land grabbing act. Now, lordship is, my lord, deciding within the parameters of, deciding or, my lord, delegating within the parameters of the settlement rules itself. Salahuddin is a, my lord,
Therefore, the question is,
lordship is correct.
I would not go. You take a decision there.
Definitely, but that, my lord, 5-tier, my lord.
No, you know,
It
it can be very
No,
well.
yes.
Sometimes a lot of people say that, okay, this order, small orders out there in the civil court, we need to challenge it. Some plaintiff challenges it. But I always advise the plaintiff don't challenge it. Because the moment you challenge it, you are delaying your suit.
Yes.
One has to understand that. And you are there to give a decision. Mr. Bora is also there. Anyway, let me
Lordship, if we file our application before the deputy commissioner, they will definitely reject.
understood. So you are giving, therefore I'm telling them, na, the moment they reject, then they will take a call. You are going to appeal in the Board of Revenue. Then you are going to come here. From here, you may
Yes.
win. And then the matter goes to division bench, then to Supreme Court.
Multiple litigation law. So better lordship, if your lordship decides that we have a bona fide claim,
I'm not going. That is what I don't want. That is what I don't want to do that. Why should we? Now you have been issued a notice. We'll construe that to be the notice. And you'll submit your reply and give all your things to the effect that you have a bona fide claim or right involved. Even those persons whom allotments have been made and everything, to give your right. And if something happens out there, you are at liberty to file an appeal. I'll mention it now. Best way.
allow me to read the letter which was written to by the deputy commissioner and secretary. That
Why don't you read this thing before the DC?
DC himself has written this.
Understood, read it
Not
before
that has
reading.
been recall, that has been
No.
recall. No.
No, understood. Recall or not, I'm saying This is, let that be decided by the DC.
Lordship. Let them file the land grabbing case then. Why they are, I read from, why they are,
How can
land grabbing.
my lord,
we are-
it is our prerogative.
Then they are at liberty to
No,
file.
all,
It is our prerogative.
don't I have to hold it that this particular, you have a bona fide claim of right involved? Do I have to hold it or not? Then only they will file. And if I hold that, am I not exercising a jurisdiction which I have stopped myself by writing a judgment in the division bench?
Very confident that is this one.
Yeah.
Very
Tell us.
confident.
But my lawyer told I could not able to show that when in the cheetah, when it was. That
No, no, no.
It's the exact position. They are
You
not
will
there.
show, let them show, you could give your evidence, whatever you feel like.
They will file individual representations.
Individual.
Individual representation.
They file all individual files, petitions.
Some of the petitions, they are,
No, everybody individual.
each of the petitioners individual, individually.
No, that's just one more submission.
Hmm.
There are 5 petitioners. Earlier, they have approached the honorable court. And honorable court directed the deputy commissioner to examine the matter. After examination of the matter, whatever your lordship now just going to that, we have to approach the deputy commissioner. That already we have approached. And the deputy commissioner has, the sub-divisional committee has decided our case and allotted some portion of land in our court, those 5 petitioners.
Then,
And some of them also, my lord, even deposit treasury challan also, the premium.
Yeah.
So, my lord, if again we go for deputy commissioner by somebody representation,
you are not submitting, you are going to show that you see, why have you approached here again?
yeah, no, because again eviction notice has been issued.
So there, you go and show that this was the order you
Yes.
gave us the settlement, and as such, I have a bona fide claim of right involved.
Yes, sir.
Mr. Sinha, kindly appreciate one very important aspect. You don't have a right to remain in government land since the government grants you a settlement. Nobody has a right. But you can be only evicted by the government by following a due procedure. This is the basis on which I exercise my
Yes,
jurisdiction.
sir. Yes, sir.
I don't exercise my jurisdiction on merits. So that is the aspect which I am going to look to that effect. That yes, if you have a right, show it. And thereafter, if there anything happens against you, Board of Revenue is there. Then yeah,
Yes, sir. And one more thing, my lord, the cheetah, they have said the cheetah, that just, I'm submitting, my lord. The cheetah, this has come subsequently, my lord. Before the, my lord, the chief minister has held meeting only in the year 2022, my lord. The proposal of constructing the second medical college has come in the year 2022.
you must have come to the late in the court.
Yes, yes,
Well,
I've come.
That is why. Otherwise, you would not have made that mistake. You see, that is why I asked him a specific question as to when it was made a TB hospital.
Yes, but that, yes, yes, I have,
Oh, you came.
yes, I've heard it well.
Then also you are asking the question. Anyway, so I asked therefore that when did you make it a TB hospital?
Yes,
He doesn't know the
Yes,
date,
madam.
it's a
Yes,
different
yes.
thing. If it is been reserved for TB hospital, then it would come within the ambit of specifically reserved.
yes, that is that, madam.
If it is being done now,
Yes, madam, that is the thing.
then
Yes,
as
madam.
subsequent to the issuance of notice,
Yes, madam.
then it would be always taken that this is a notice issued on the basis of being a wasteland.
Yes, madam. Yes,
So you
Yes.
know all these things.
Yes, madam.
I need not advise you any further.
Yes, madam, yes, madam.
Yes. For what?
That reserve land, that what she is asking, that it is reserved for TB hospital, my lord. No such notification is there, even there is no record is also there, my lord.
Tuka of Mondol. Tuka of Mondol, not by circle officer. Tuka of Mondol is there. Not by, no order has been passed by settlement officer. No, the 41 that.
No, for the purpose of if a land is being reserved, the revenue department has to settle it
Yes, my lord.
with a particular department.
That was also that your lordship has that criteria has been that your lordship in the division bench referring to the reference case. That if the land is previously reserved for money, if that present land, second hospital is not previously reserved.
It is what
Yes, my
take
lord.
the benefit of the judgment.
Yes, yes. Not previously reserved, my lord.
Let me come back and I'll deliver the judgment. Madam, I would not go much into the facts, because of the fact that if I go into the facts, it may prejudice either of the parties. You go and submit whatever it is. I'll construe the notices which have been issued to you as notices to vacate. And as such, you are being given the permission to, the liberty to submit your representation along with further documents as you feel so to prove your case. And the deputy commissioner will give a hearing to the persons. You give a hearing to the person before taking any decision on the report. I'm coming, Miss Enbodley appears on behalf of the revenue department. And Mr. S.R. Bolu appears on behalf of the district administration. You are appearing? Mr. What role you have? And Mr. S. Bora appears on behalf of the GMC. You gave permission to them to construct also.
There are reports of there. They have, the government has sent a letter to them to give the NOC for construction of the houses. Train.
The repetitions, all the batch of repetitions, except WPC number 2174/2024, have been filed, challenging their individual notices issued to the petitioners in the petitions. Under Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulations 1886, for short, the regulations. For the purpose of this disposal of the batch of petitions, it is pertinent herein to take note of the individual cases of the petitioners in their petitions. In WPC number 7816/2022, the petitioner, who is in occupation of ten lessons of government admitted government land in Dag number 96, had constructed an RCC building, and a notice was issued under Rule 18 on 10/11/2022, which is the subject matter of challenge. In WPC number 7948/2022, the petitioner is in occupation of 1 kata 10 acres of land by constructing an RCC building which is covered by DAG number 96, which is admittedly a government land. In this case also, the notice was issued on 10/11/2022, which has been subject matter of challenge. In WPC number 7949/2022, the petitioner is in encroachment. Petitioner has occupied 1 kata 5 acres of land by constructing RCC building, which is covered by DAG number 96, which is admittedly a government land. The notice was also issued on 10/11/2022. In WPC number 7970/2022, the petitioner is in occupation of 8 acres of land by constructing an Assam type house. And the notice was issued on 10/11/2022. The land occupied also falls in the government DAG number 96. In WPC number 7580/2022, the petitioner is in occupation of 10.07 acres by constructing an Assam type house, RCC building over the government land being government DAG number 96. In this case also, the notice was issued on 10/11/2022. In WPC number 7848/2022, the 3 petitioners have encroached, are in occupation of 3.54 R are in occupation of land at measuring 3.54 R over DAG number 201 and 8.72 R over DAG number 202, totaling to 12.26 R, and have raised Assam type house. These DAG numbers 201 and 202 are government lands. The impugned notice was issued on 10/11/2022. In WPC number 3715/2020, there are 11 petitioners who are in occupation of government DAG number 97 of an area at measuring how much?
My lord, this is my lord 2.70.
No, everybody,
Yes, everybody total, my lord.
just calculate it and give it to me, huh? At measuring so much R, A-R-E, huh? And they were issued notices on 10/11/2022. It is pertinent to mention that initially the petition was filed apprehending and subsequently on the basis of an interlocutory application being IA number 3377/2022. The notice which was issued was uh, 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 the notice which was issued was pursuant to the notice so issued, a status quo order was passed. We give that, ask them, huh, to make the calculation total.
For the 11 petitioners,
Huh? How much?
so for the 11 petitioners, the total area under occupation is that we are to.
In WBC number 1361/2022, the petitioner is in occupation of 12 acres of land by constructing an Assam RCC building over government DAG number 97. And the notice was issued on 7/1/2020, which has been put to challenge. In WBC number 7, in WBC number 7510/2022, the petitioner is in occupation of 1.97 acres of land, of government land, covered by DAG number 97, by constructing an Assam type house. In this case, the notice was issued on 10/11/2022. It is pertinent to mention that the petitioner herein had applied for settlement, which was, however, rejected. In WBC number 7517/2022, the petitioner is in occupation of 1.48 acres by constructing an RCC building and in building over government DAG number 97. The impugned notice was issued on 10/11/2022. It is pertinent to mention that the petitioner applied for settlement, which was, however, rejected. In WPC number 78618/2022, the petitioner is in occupation of 11 acres of land by constructing an Assam type house over government DAG number 97. The impugned notice was issued on 10/11/2022, which is the subject matter of challenge. In WBC number 7622/2022, the petitioner is in occupation of 14 acres of land by constructing Assam type house over DAG number 97. And the petitioner was issued notice on 10/11/2022. In WPC number 7698/2022, the petitioner is on occupation of 1.96 acres by constructing an Assam type house over government DAG number 97. The impugned notice was issued on 10/11/2022, which is the subject matter of challenge. It is pertinent to mention that the petitioner herein has sought for settlement, which was, however, rejected. In WPC number 7736/2022, the petitioner is in occupation of 2.68 acres by constructing an Assam type house over government DAG number 97. The impugned notice was issued on 10/11/2022, which is the subject matter of challenge. In WBC number 37804/2022, the petitioner is in occupation of 14 acres of land by constructing an Astin Chali house over government DAG number 97. The impugned notice was issued on 10/11/2022. In WBC number 7815/2022, the petitioner is an occupation of 17 hectares of land by constructing an Assam type house over government Dag number 97. The impugned notice was issued on 10/11/2022. In WPC number 7818/2022, the petitioner is in occupation of 3.06 hours of land by constructing a Teen Charlie house over government Dag number 97. The impugned notice was issued on 10/11/2022. In WPC number 7823/2022, the petitioner is in occupation of 3.34 hours of land by constructing a Assam type house in the scale over government Dag number 97. The impugned notice was issued on 10/11/2022. In WPC number 7831/2022, the petitioner was in occupation of 0.67 hour of land by constructing a Teen Charlie house, which is over the government Dag number 97. The impugned notice was issued on 10/11/2022. Dag number 97, eh? अब रिसोर्ट to लिखो. In WPC number 7858/2022, the petitioner is in occupation of 12.50 hectares of land by King Legil 97. Ako 10/11/2022. In WPC number 7870/2022, the petitioner is in occupation of 2.55 hours of land by constructing an Assam type house over Dag number 97. The impugned notice was issued on 10/11/2022. In WPC number 7953/2022, the petitioner is in encroachment of is in occupation of 10 hectares of land by constructing Teen Charlie house and the impugned notice was issued on 10/11/2022. In WPC number 7976/2022, the petitioner is in occupation of 15 hectares of land by constructing an Assam type house over Dag number 90, government Dag number 97. The impugned notice was issued on 10/11/2022. In WPC number 8308/2022, the petitioner is in occupation of 7.5 hectares of land by constructing an Assam type house over Dag number 97. The impugned notice was issued on 10/11/2022. In WPC number 186/2023, the petitioner is in occupation of how much land?
Land, my lord, they have not spelled out, but they.
Yes, 186. Who is appearing?
This is Arun Mandal,
Arun Mandal.
using that land by constructing a godown, and they had also filed a title suit which was dismissed.
Huh?
1 kata 5 decimal.
1 kata 5 hectares of land over government Dag number
Yes.
97 and had also constructed a godown. The impugned notice was issued on 10/11/2022. It is pertinent to hearing to mention that a suit was filed being title suit number. You filed a suit,
Yes, they had filed a suit which was dismissed.
suit number. Had filed a suit which was, however, dismissed. In WPC number 221/2023, the petitioner is in occupation of 1 kata of land and or 1 kata of land in government Dag number 97 and had constructed an Assam type house. The notice was issued on 10/11/2022. About 10/11/2022. So in this regard also, the petitioner had filed a suit which was dismissed. In WPC number 922/2023, the petitioner is in occupation of 1 katha of land and had also constructed an RCC building. It is pertinent to mention that the building over government Dag number 97. The impugn notice was issued on 10/11/2022. The petitioner had filed a suit which was also dismissed. In WPC number 1006/2023, the petitioner is in occupation of 1 katha 5 acres of land by constructing Assam type house over government Dag number 97. The impugn notice was issued on 10/11/2022. In this case also, the petitioner had filed a suit which was however dismissed. In WPC number 5880/2023, the petitioner is in occupation of 1 katha 5 acres of land by constructing an Assam type house over government Dag number 97. The notice was served on the petitioner on 22/9/2023. The impugn notice was issued on 22/9/2023.
These are subsequent notices. They were not issued with notices under 10/11/22, but these were the first notice that came to be issued.
Which is the subject matter of challenge. In WPC number 5959/2023, the petitioners are in occupation of 12.5 acres of land by constructing an Assam type house over government Dag number 97. The notice was served on the petitioner on 10/11/2022, and subsequently another notice was issued on 22/9/2023, which are both subject matter of challenge.
So far as that WPC 3715 of 2020, the total area would come at 19.44 hours. 19.44 hours.
In WPC number 7258/2022, the petitioner herein is in occupation of 2.40 hours of land and had also constructed an Assam type house. In this regard, the petitioner was issued a notice on 10/11/2022. It is, however, very pertinent to observe that the petitioner herein was pertinent to observe that the Revenue Department of the government of Assam had by a communication informed the petitioner that his land, the land had been allotted to the petitioner and was directed to deposit the premium. It is also relevant to mention that the petitioner had thereupon deposited the premium, which is still retained by the government. However, there has been no issuance of any patta
Settlement.
lease, the periodic lease. In WPC number 7381/2022, the petitioner is in occupation of 1 katha 5 acres of land of Dag number 97. I go to Dag number 97. And had also constructed an Assam type house. The petitioner was issued a notice on 10/11/2022. It is very pertinent herein to mention that in the instant case, the government had on 15/2/2022 had accorded approval for allotment or settlement.
Well, for minor settlement subject to realization of the premium.
Settlement subject to realization of the premium and recommendation from the Guwahati Metropolitan Development Authority.
Yes.
However, there has no recommendation being made by the GMDA Pusto.
No action has been taken, my lord, formally to settle the land.
In addition to that, there has been no further decision has been taken in regard to the approval order of settlement in respect to the petitioner in the instant case. Here, premium not deposited, na?
No.
It is further mentioned that the premium had also not been deposited by the petitioner.
For taking the.
In WPC number 7382, the petitioner is in possession of 15 letters of land and have also constructed an Assam type house. The government, the revenue department of the government of Assam had accorded approval for settlement on 23/2/2022, subject to realization of premium and recommendation from the Guwahati Metropolitan Development Authority. No recommendation report have till date been submitted for and the premium had also not been deposited.
Not been deposited. No formal order of settlement has been issued.
In WPC number 7383/2022, ইয়াতে notice kon issue করেছে on 10/11 there. In the instant case, the notice was issued on impugned notice was issued on 10/11/2020. And next. In WPC number 7383/2022, the petitioner is in occupation of 2.88 R by constructing an RCC building. Also, certain proceedings were initiated for settlement of land in favor of the petitioner. However, there is no formal order. There is no but the revenue department, unlike but the revenue department was yet to accord the approval for settlement. First, in this case, the notice was issued on 10/11/2022. In WPC number 7384/2022, the petitioner is in occupation of 2.88 hours of land by constructing a Teen Chali house. Similar to WPC number 7383/2022, although certain proceedings were initiated for settlement of the land, but however, there has been no approval accorded by the revenue department.
Impugned notice
In the instant case, the impugned notice is dated 10/11/2022.
Madam.
In WPC number 7389/2022, the petitioner is in occupation of 1 Katha 5 letters of land covered in Dag number 9, government Dag number 97 by constructing an Assam type house. In the instant case, also certain proceedings were initiated for settlement of the land. However, there has been no according of any approval by the revenue department. Notice was issued on impugned notice was issued on 10/11/2022. In WPC number 7399/2022, the petitioner is in occupation of 2.68 R of land by constructing an Assam type house over Dag number covered by Dag 2.68 R of land by constructing Assam type house over government Dag number 97. Footstep. In the instant case, certain steps were taken for seeking clarifications by the circle officer, but nothing further proceeded as regards the settlement. In the instant case, impugned notice was issued on 10/11/2022.
Now,
That is further mentioned.
item number 66, that is the new one. That WPC 2 was.
Where
there.
will I get that?
Well, that I have not mentioned in, it's in abscess, my lord, but in the rate petition, well, they are in occupation of Item 66. 66 of file to be. 66, item 66.
I'll take care of that. Wait, I'll hit file. In application number 2174/2024, did you include all others? All others are here, 2024 matters are here?
This matter is right, my lord. Same petition, right?
There is no 2024, I've said.
No, item 66.
Now, in this case, there is no 2024.
Yes, yes, in that synopsis, it is not there, my lord.
All these 2024, no notice has been issued. 2148 and 2174, that's all. 2148. Abhi to start karo.
65, item 65 and 66. Yes. They are basically against, my lord, the move taken by the government for recording the orders. Earlier, my lord, the orders that were issued in their favor. Now the government has taken a stand, my lord, that these orders are to be recalled. So against that, my lord, these two petitions are pending.
So these have nothing to.
Yes, yes. No, 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 no. It is
Eh, eh,
one of
eh,
the
that's
earlier
like,
petition.
Don't bring these two matters, huh? 2148 and 2174 separately deal with, because these are subject matters are different. এই ওপৰত এটা লাইন এটা কৈছিল ন 2174 বেলেগ বুলি হয় বুলি এই বস্তুটো কাটি দিওঁ আগত লিখিছো first. From the brief facts and the reasons for which the repetition of facts from the brief facts stated in respect to the repetitions above mentioned repetitions, it would be seen that the petitioners herein have approached against the various notices issued under section 18, rule 18 of the settlement rules. The petitioner's specific cases that the summary procedure of eviction under Rule 18 cannot be resorted to against the petitioners, taking into account that the petitioner have rights for settlement of those land of the lands where they are in occupation as per the land policy of 2019. And further to that, and in that view of the matter, the petitioners have also a bona fide claim of right involved. The learned counsel appearing on behalf of the petitioners have submitted that as the lands in questions wherein the petitioners are in occupation are government wastelands, such action taken by issuance of the impugned notices directing the petitioners to vacate without giving an opportunity to the petitioner to show that they have a bona fide claim of right involved is in violation to the principles of natural justice as well as the central principle of law as laid down by the division bench of this court in the case of Salakuddin Mohammed
Mohammed Salakuddin
versus State of Assam,
State of Assam and other
reported in
quoted, my lord, I will check it. It is otherwise, my lord,
2024 SCC online, GAU. Yeah, it's there in some GLT, GLR everywhere. It's there now. Mohammed Salahuddin is reported everywhere. What I say? In so and so. Mr. Anything else?
Lordship, so far that this land does not fall under the TBO hospital, which was not never allocated to the TBO hospital. That Lordship may observe.
It has also been submitted that the repetition that the state government that at the time when the petitioners have entered in possession of the lands under their occupation, the revenue records never show that the lands were land in the dance in question were previously reserved for public purpose. However, subsequently, an attempt is being made by the government to show it to be land specifically reserved for TB hospital, and subsequently, during the pendency of the instant petition, have been shown to be in the name of the second medical college. The learned councils therefore submitted that as the lands were not previously reserved, the consideration of the petitioner's cases are to be taken on the basis that the lands in question are government wastelands. Anything more? Mr. Arbor Budari, the learned counsel appearing on behalf of the Revenue Department, on the other hand, submitted that the petitioners have no right to remain in occupation of the government lands without there being any settlement or patta being issued. He referred to Rule 16. Rule 16, na?
Yes, Rule 16.
Of the
prohibition to-
settlement rules, which categorically mandates that no person shall remain in possession, shall enter into possession of the government lands without the
Without written permission by the deputy commissioner.
without the written permission of the deputy commissioner or settlement.
Pending issuance of such lease.
I'm like,
Have this-
wait, I have that. Sitting in bench 5, if I don't have that, then heaven will. Submitted that Rule 16 of the settlement rules categorically prohibits entering into government land until lease is being issued. He further submitted that in certain cases, the deputy commissioner may grant written permission, and in such issue, written permission when
The pending issue of such lease.
permission pending issuance of the lease. the learned counsel for the revenue department further submitted that merely because the petitioners are in occupation over the lands in question does not confer any right upon the petitioners. More so in view of Rule 15, which categorically stipulates there is one near is there now wherein
Have any right to settlement merely
wherein it has been mentioned that no person shall have any right to settlement merely because he is in occupation of the land not included in any lease granted by the state government either to himself or to any other person. In addition to that, the learned counsel further referred to the Assam land policy of 2019, wherein he referred to clause
Yes,
14.3,
yes,
which
14.6.
categorically stipulate that the government will not consider settlement of any government land in Guwahati city or in any other town area under possession of an individual or other persons, merely on the ground that the person concerned is in occupation of such land, irrespective of the period of such occupation or encroachment. He further submits that the policy of the government is to consider settlement or to evict as the case may be, depending upon the discretion of the state government.
And my lord, the deputy commissioner.
In
had-
addition to that, the learned counsel further submitted that these particular lands have been specifically earmarked for the second medical college, taking into account the public interest as well as the urgent necessity of having an additional medical college apart from the presently functioning Guwahati Medical College. He therefore submits that these petitions ought to be dismissed as the petitioners have no right over the lands in question, no right to remain in occupation of the lands in question. Mr. S.R. Bulwa, what do you have to say? Mr. Arbogari, is over?
You know,
Don't you talk? You are the main person.
The ball is in his court.
Huh? Mr. S.R. Bulwa, the learned counsel appearing on behalf of the district administration, submits that taking into account the judgment in the case of Salakuddin, Supra, Mohammed Salakuddin Supra, the Deputy Commissioner, Kamrup Metro, Supra, taking into account the judgment of the court in in MD Salakuddin Supra. If this court directs the petitioners to submit representations, the Deputy Commissioner Kamrup shall duly consider the same on its merits. But he can't adopt the moment he does, immediately by
Along with all the relevant documents, along with all the relevant.
wait, that is his submission.
Okay, yes.
This court have also inquired with Mr. Espora, the learned counsel, appearing on behalf of the GMDA, who is also the standing counsel of the GMC, as to whether any permissions have been granted as regard to the petitioners for making constructions he categorically submits that these constructions which have been carried out by the petitioner have over the lands in question are without any permissions. I've heard the learned counsels appearing on behalf of the petitioners at length and given my anxious consideration. Where is that Salahuddin judgment which I was not here? From the materials and report, it appears that there is no denial to the fact that the petitioners herein are in occupation of government lands. The fact as to whether the petitioners have any bona fide claim of right involved over the government land, or have any rights over the government land to remain in occupation, or as to whether the summary procedure could be resorted to against the petitioners by invoking the powers under Rule 18 is dependent upon the decision as to whether the petitioners have a bona fide claim of right involved. This court have also taken note of the land policy of 2019, which stipulates that stimulates certain conditions, stipulates that an indigenous person having no land would be considered for grant of settlement. This very aspect settlement subject to the person showing that he fulfills the conditions as per the Assam land policy of 2019. However, in order to show that the person concerned has a right to remain in occupation, or for that matter, that summary proceedings for eviction cannot be resorted against the petitioner, against the petitioner. The petitioners ought to be given an opportunity of hearing, as has been held by the division bench of this court in Muhammad Salahuddin Supra. This court have also perused these notices wherein it has been shown that the petitioners were directed to vacate. Taking into account the fact that the petitioners have been issued such notices, the said notices shall be construed to be notices asking the petitioners to explain as to whether they have any bona fide claim of right involved in the said in the land in question. Accordingly, this court therefore disposes of the instant batch of these petitions with the following directions and observations and directions. The petitioner cannot be evicted. The impugned notices under Rule 18, so issued to the petitioners to vacate, shall be construed as notices issued by the by the concerned officer, circle officer, na? By the circle officer, Guwahati Revenue Circle, as notice within the meaning of as a notice under Rule 18 to explain as to whether the petitioner has any bona fide claim of right involved. Number two, the petitioners, no, in view of the said, in view of the above, the petitioners herein are given the liberty to submit individually replies along with documents and such evidence as deemed fit to show that the petitioners have a bona fide claim of right involved in the bona fide claim of right involved in respect to the land under their occupation. This court, instead of this court, directs the petitioners to submit such representations before the Deputy Commissioner, Kamrup Metro, because don't make it the 5th. Don't make it the 50th Guwahati. Because if we go to circle officer to Deputy Commissioner to some board of review, repetition first round, repetition.
They will submit representations, individual representation before the Deputy
To the
Commissioner.
Deputy Commissioner,
15 days from today.
Kamrup Metro. Within 30 days from the date of the instant order. The Deputy Commissioner, Kamrup Metro, is directed to give due hearing to the petitioners. I said 30 days, na?
30 days.
The Deputy Commissioner, Kamrup Metro, is directed to give a due hearing to the petitioners. And after hearing, the petitioner, the Deputy Commissioner is directed to give a opportunity of hearing to the petitioners. Either through them or through their council
First,
authorized representative.
hearing, individual hearing.
Don't make it that one. We'll have another file. I said this, he knows what to do. Hearing. That again, he will come for that. In the
But the authorities will get, some authorities may get some help, otherwise.
Now, if I give individual hearing, you want, I can. There's no problem. You want, the Deputy Commissioner shall give individual hearing, shall give
Hearing.
an opportunity
Appropriate
of
hearing.
hearing to the petitioners.
Definitely.
Either through themselves, either through the, or through them or through their authorized representative. Thereupon, the Deputy Commissioner shall pass appropriate orders. It is further observed and directed till such decision is passed. Appropriate speaking orders. It is further directed that till such appropriate speaking orders are not passed, no action be taken of eviction against the petitioners.
The representation to be submitted by the petitioner shall be accompanied by a copy of today's order, madam. Please, set the time limit. This will give a matter of sanctity to the proceedings, madam, time limit. Today. Shall be getting.
What do you want? The copy of the order. Why?
Maybe,
Photocopy.
that should be enforced with, madam, they have representations, otherwise, madam, they will file a representation, madam. No, my lord.
We had a petitioner, I have given the power, yeah. I've not given it to anybody else. You have a copy of the order.
We have a
So
copy.
this order, they will tell you the person.
We will communicate.
Because it will be the same copy, everybody.
Yes, only a copy of the order. I'm not showing my.
One copy.
One copy. And
Why do you need everybody a copy? Why are you so not environmentally friendly?
I'm not making a submission that they will be. They
No,
will
give me
not
the
find-
good, no, give me a good reason why.
Some people, they come, it will be like this.
Because we will communicate, we will immediately, my lord, after my lord's order is my lord available in the website, we will
At a line.
immediately communicate.
The deputy commissioner, Kanu Petro, is directed to allot a particular area by way of a notice wherein such representations in respect to the present lot of writ petitions is to be submitted.
Otherwise, there
Why I am saying is very clear. Then once he does it, then he will put a stamp and finish it. If they don't give, they don't give. How does it matter?
they will be filing a representation in pursuant of today's order. So, my lord, only
Mr.
a copy-
Portugal, kindly appreciate one thing. The certified copy will be this big.
I'm not going to- I'm not making a submission that they should find a certified copy, only a copy, downloaded copy of the order, that will.
Understood, the downloaded copy will be this big. Why you are not understanding that? All these, so many repetitions. Everybody's name every time comes, it doesn't come with one name.
But their representation should have some indication that it is in pursuance of today's order, that much. That much.
That at a line, at the upper at a line, the upper listening petitioners shall submit their representations, shall submit their written, that लिखियो. In the said representation, the petitioners herein shall indicate in which petition the petitioner was a party. One has to be also environment friendly. Otherwise, they will have a one-page representation in this big.
I'm so grateful. We are always grateful. I cannot. But then I can 65, 60. We'll withdraw that. Item number 65 and 66, we are not pressing.
Not pressed.
These citizens are already included in this months of report because we are now satisfied.
The Aadhaar, the learned, you had a petitioner in both?
Yes.
It's the Aadhaar, the learned counsel appearing on behalf of the petitioner submits that in view of the order passed in, the earlier petition, give me, in which case you were there?
Madam, one is Madam 7381 or
For 2148, which one is the other earlier?
for 2148, my lord, it is 7389 of 2022.
7389 oblique 2022.
Or my lord, 2174 of 2024, it is my lord.
9 of 2022 submits that he would not like to press the instant petition. Accordingly, the writ petition stands closed. Are you gonna 2174?
7381. 7381 of 2022.
Order passed in suits.
Deeply open. I am so grateful, my lord.
At last, the series is gone.
Yes, sir.
Of daily list.
Mr. Barbadari, ask your DC to allot an area.
Right now, we will be communicating.
Because these type of matters, you need to do it. Otherwise, they will just say, I have filed it somewhere because you have to file it online. This online business, it will be very difficult. Give the title sheet. Where are those? Everybody gone. How did you know that there are title sheets?
part of their repetition
No,
pleading.
no, they must have given the number.
Yes, yes, yes. It's a part of their pleading.
Kindly give the number.
Yes, yes, yes. We will give it back.
Yes, who is there? Item number, Nipul Kumar Das.
I don't know, I think the matter. They have filed two petitions for two mistakes, two interlocutory applications, one for condemnation of the and another for the substitution. They have not come up with the petition. Perhaps they need to be considered.
This is against what order?
My lord, the petitioner, while he was serving in the CRPF, he went on leave and thereafter he was diagnosed with attention deficit syndrome with brain atrophy.
Hmm.
Now, for the period of absence which he overstayed, he felt that disciplinary proceeding found it to be a misconduct and compulsorily retired. And it is that order of compulsory retirement is under challenge.
Compulsory retirement? Compulsory retirement is what? Isn't it, is it a penalty?
The penalty in this case, because there was a disciplinary proceeding, a memorandum of charge, disciplinary proceeding was held, found guilty and penalty imposed. Had it been because of his medical condition or because he had outlived his service into the detention.
The inquiry proceeding, the inquiry officer took statement from. The police and yes, people. So he's being given the pension and gratuity.
Yes, but his service was cut short. His
Now,
service-
what is the relief which the representative can get?
My lord, if the disciplinary proceeding is set aside or if success in the case, then his service should be continued at least notionally till the date of his death.
Well,
That is around 11 years of service, my lord, for which he would now, he would be entitled for a higher pension and the discharge benefits. Another aspect which the wife has now pointed out is while paying the benefits, retirement benefits, the department had deducted certain heavy amount of about 10-12 lakhs from his
How much?
retirement benefits, about 10-12 lakhs. Madam.
Why?
My lord, they say that the period of his absence and the period of his hospitalization, he would not be paid for that. After paying him the salary during the disciplinary proceedings, on his retirement, it has been recovered. So unless one of this misconduct parties goes and the retirement, she suffers in her retirement benefits.
Mr. R. Mazumdar, learned counsel appearing on behalf of the petitioner submits that the petitioner had expired and there are two applications filed for substitution of the legal representatives as well as for substitution of the legal representative as well as the condemnation of delay. Taking into account the above. Taking into account that the right to sue continues, taking into account the above as the right to sue continue as in view of the order of penalty imposed, this court, which would have a bearing on the fixation of the pension and gratuity. This court fixes this matter again on 14. We'll have it on 21st. On 21st of November 2024, the registry shall bring on record the same. Because you see, if there's otherwise in any other court it goes now, it won't happen. Because I have been only endorsed for those people, these old matters only for this. So otherwise, I specifically told them these matters needs to be finished off. Otherwise, people, if they are to get, they should get.
The I numbers I have of both the
I number so and so.
I number 3379 of 2024, and I number 3380 of 2024.
For hearing. Huh? For hearing. If it is for hearing only, it will come, otherwise it will go to any other bench. Because we will implead them and then hearing. Flesh, Mr. Odhikari, be ready. Yes, what is this? See the who submits that the matter has been
Impugn order of dismissal is under challenge. Challenge is on two grounds, my lords. First, my lords, the order of dismissal is an outcome of a review, my lords. Suo motu review by the appellate authority, which had reversed the penalty of the disciplinary authority. So the first contention is, my lords, that review is barred by limitation, because as per the rule, the review should have been initiated within a period of 6 months. Apparently, my lords, the review was initiated after the 6 months, after the expiry of 6 months. The second ground is on parity, my lords. Similarly situated employees, my lords, who were together in the show cause notice, similar allegations, they were given lesser penalty. So, my lords, it's the grounds are, insofar as I can gather, my lords, there are two grounds mainly, my lords. First, that review. Now, what calls for consideration by this honorable court, my lords, is the fact when would it initiate, my lords?
Wait. First and foremost,
My
let us first see impugn order of dismissal, 26/8/2015. Why?
15. At page 126.
Yes.
Well, this is the initial order of penalty was reduction to 2 scale lower in time scale for 2 years, which my lords would find that page 112.
Time scale of pay for 2 years with a further direction that he will not earn any increment during the period of suspension. Expiry of the said 2 years, increment shall be on reduced pay scale.
My lords, my lord, may kindly note the date, my lord. It's
Yeah.
passed on 12/9/2014.
Where? Ah, 12/9.
12/9/2014. Thereafter, my lords, if my lord comes to page 114,
Hmm.
page 114,
Hmm.
the petitioner, after the penalty was imposed, was again put under suspension, and he was intimated or rather informed that we are about to initiate review proceedings against you. I'll just read the order, my lord. Page 114.
Hmm.
Whereas Shri R.K. Nyong, Superintendent Engineer so-and-so, was charge sheeted in 2 cases under Rule 36 and the appeal rule so-and-so by memorandum dated so-and-so, memorandum dated so-and-so. Whereas an inquiry was conducted by the CDA Director in exercise of powers delegated under Section 35 of the ONGC Conduct so-and-so rules, had imposed the penalty of reduction of 2 stage lower in time scale, such and such. Whereas the CMD, well, this is important, as reviewing authority in exercise of powers vested under him under Rule 54, IBED, has decided to review the penalty imposed on Shri Nyok and place him under suspension with immediate effect. Now, my lords, this is, my lords, first of all, he was put under suspension. Insofar as suspension is concerned, my lords, suspension, my lord is aware, my lords, it has to be by way of the rules. Now, the rules do not envisage a suspension pending review. So that is an admitted point, when I'll come to the rules. As per the rules, in terms of,
Tell me.
yes, ma'am. As per the rules, my lords, a person can be suspended in contemplation of a disciplinary proceeding if he's behind bars for 48 hours, that's a deemed suspension. There is no provision for suspension pending a review petition, my lord, a review, my lord, of the order. And my lord, this order at page 114, it was issued after 5 months, 25 days from the date of the initial order. So insofar as the order in page 114 is concerned, that is not beyond 6 months. But thereafter, my lord, that is not beyond 6 months. This order was issued after 5 months, 25 days.
Which month?
114, that I was placed under suspension.
Yeah.
But my lords, what the rules envisage, the rule says that the review has to be initiated. It does not use the word inform or intimate. It was initiated only on, my lords, page 115,
on 20/03/2015, when I was asked to show cause. Page,
No, no, initiated by this order.
no, I'll come to that. Page 150. This is the show cause.
Then
Show cause notice on 20th March 2015. That is admittedly issued after 6 months, 10 days, my lord. Now, my lord, kindly take up the rules for a moment.
raise that.
There's a CBA rules over in this. No, my lord.
Here.
My lord has it, my lord.
ONGC conduct and discipline.
Exactly.
Oh, somebody heard this matter in 2024.
Yes, my lord. It was,
This is Sumitra Sekhe.
it was released from Parliament.
This is Sumitra Sekhe.
Yes. My lord, may kindly come to 54. That is the power, my lord. Review. Rule 54. May I read, my lord? The authority to which an appeal against an order imposing any of the penalties specified in Rule 34 lies may on its own motion or otherwise call for the records of the case of the disciplinary proceedings, review any order passed in such a case, and pass such orders as it may deem fit, as if the employee had preferred an appeal against such order, provided no action under this rule shall be initiated. Whereas the word used is initiated more than 6 months after the date of the order. In fact, my lord, how will it will get initiated? That has also been provided probably, my lord, in the explanation. My lord, kindly see. No order. The explanation note, my lord. No order imposing or enhancing any penalty shall be made by the reviewing authority unless the employee concerned has been given a reasonable opportunity of making a representation against the penalty proposed. Now, this opportunity was only granted to me on 23/2015 by way of the show cause notice. Now, my lords, just as an illustration, my lord, now I was informed that a review they would initiate review or whatever, but they're not initiated till date, my lord. Then that can be prolonged for years, my lord. They may not issue a show cause notice. In that case, will that 6 months period get extended? And again, my lord, I'll show before this honorable court, my lord, the word initiation, at least in disciplinary, in service law, my lord, has been well settled, my lord. My lord is aware, my lord, even in a disciplinary,
Yes.
even in a disciplinary proceeding, my lord, disciplinary proceeding is not initiated when a person is put on person is placed on suspension pending disciplinary proceedings. It is only initiated when the show cause or the charge sheet is served upon the delinquent employee.
How will it be initiated anywhere mentioned?
My lord, has been derived from the explanation, my lord.
What does it say?
No order imposing or enhancing
So
any
you mean
penalty
to
shall.
say without, at the time of only the show cause, when it is being issued, it would amount to initiation.
Yes, that judgments are there. Please, may I?
Judgments are there, but whether the judgments are in context of this type of.
Yes, in
rules-
context, my lord. In fact, my lord, there are other judgments with regard to the word initiate pertaining to contempt of court. Even my lord is aware, section 20 of the Contempt of Court Act. It says the court may initiate. They use the word initiate. Now, in cases of suo motu initiation, the Honorable Supreme Court has held that it is only on serving a show cause notice or issuing a charge sheet, only then it would initiate. Now, in service law also, my lords, there is a judgment of the division bench of the Honorable Andhra Pradesh High Court, my lords, dealing with a exactly similar situation, my lords. They have interpreted the same pari materia rules, my lords. If I may be allowed. Okay. My lord, just give me a moment.
How many years of service left?
My lord, I've already superannuated.
Then what do you want?
My lord, back wages, because it's dismissal is no pensionary benefits, nothing. Now, again, that my first ground is initiation, my lord. That the review itself was without jurisdiction. The second is again on parity, my lord. There are tons of judgments, my lord, which says even in cases of penalty, Article 14 has to be followed. So similarly situated people, their orders were never reviewed and they were not dismissed from service. That all place judgments, my lord. In the same charge sheet, there were number of superintendent engineers, my lord. Same transaction, same case, my lord. I was the only one who was dismissed from service by suo moto reviewing the penalty after the period of 6 months had expired. Now that judgment. What? Problem with the printer, it's not very dark, my lord. Judgment, division bench of the Honorable Andhra Pradesh High Court, my lord. Just give me a minute. My lord, the relevant paragraph, my lord, may come to paragraph 4, my lord. Paragraph 4. My lord,
Criminal proceedings was initiated against you.
yes, I was acquitted. My lord.
You acquitted.
I
Beyond
placed
reason.
it on record. I placed it on record, the judgment.
Acquitted how? Where? Andhra Pradesh High Court is here. I got someone. Somebody gave this. Scope and application review of an order of punishment by appellate authority power proceedings were initiated within 6 months from the date of your mayor calling for the
Paragraph
court
4.
does not amount
Paragraph. May I read, my lord?
to following to the-
Supreme Court was interpreting Rule 29, the CCS rule.
So many judgments you have given.
This Andhra Pradesh judgment, when the facts are almost similar. my lord. The same question arose there. my lord.
But the word initiation is not there
Yes, it's there.
in Rule 29 of Andhra Pradesh judgment.
Right.
Yes, others can go, I suppose. Huh? What is that? Mr. Mohanto will trouble me for the evening. Yes, Mr. K. Majumdar. Huh?
That item element. And as with that item element. They are not.
Well, next week.
Next week, it may be listed next week and they are not.
Okay. Hey, so 11 to next week will do. Tuesday would be difficult, but okay, Tuesday at 2. At 2, we'll take it.
Number 8.
Tuesday. No, 1 is enough. Thursday. Thursday is 14, nah. 14 would be difficult. I would be writing a bit early. 14. Not possible. Today he has taken me. Mr. P. Mohanto is taking a long time. You may let it. I have asked the registry to get hold of these are hearing matters which have come only for the purpose that I've asked the registry to get it listed. So these are matters which never happen otherwise. So I'll ask the registry to again list. Don't worry. You don't have a pension bench nowadays? What has happened to the pension bench? Huh? Okay, registry totally list they will list it again. Yes. Where's the word initiate in
It's not,
Rule 29?
it's not there.
Ah.
29 initiate is not there, my lord. But the word initiate, my lord, I'll come to other judgments. But before that, my lord, I'll place the Ramanatha Iyer.
No, why I'm saying that particular order by which a decision is being taken, that they would review, putting that amount to initiation.
No, my.
That's the case.
In my
Your
humble
long and
submission-
short issue is this.
Exactly. In my humble submission, that would not amount to initiation, my lord, because the word initiate itself means to commence. Now, my lord, in every case, even in the case of a disciplinary proceeding, my lord, if there's a misconduct against a delinquent employee, the disciplinary authority can always suspend the person, but that does not mean that the disciplinary proceeding has initiated. It would always be initiated at the time when he is show cause, that these are the grounds under which we seek to.
Because suspension is different from initiation.
Yes.
I think that's different aspect.
Yes.
But the fact that a suspension, therefore, in that case, I forgot the name. That case, Ajay Chaudhary.
Adresh, Chaudhary.
You say, therefore, the initiation is not being done without issuance of the memorandum of charges.
Exactly.
For
All the
years.
charges.
On the other hand, people are kept under suspension. So therefore, suspension is different from initiation.
Yes.
But the fact that it's a conscious decision to taken to initiate, that we are going to initiate, wouldn't it imply that there has been an initiation?
My lord, the word intimate would be construed differently from the word initiate. Yes, very well, my lord.
I'm
They
not
had-
saying about the intimate. Intimate would be different.
Yes.
But just for example, you commit some problems. I ask the Chief Justice that Mr. P. Mohanto has behaved not properly in the court, so kindly initiate here.
Proceeding
Chief
for
Justice puts it on the order, taking into account that he is the division bench. It would be a criminal contempt that he has given. he passes an order to that effect that why not so and so. And as such, he directs to list the matter before the court. So this has to go administrative. Then the matter comes and then he issues notice. You are not there. The fact that a conscious decision is being taken that yes, fundamentally a case is being made up for the purpose of the initiating the process. It passes an administrative order to list it before the court. Wouldn't that be initiation?
My lord,
Which has happened here.
in that case, my lord, there's a judgment, my lord, exactly on what fell from my lord, my lord. There, the question was, in contempt, when will the contempt initiate? Now I'll place that judgment, my lord. And that, my lord, it will be very dangerous, my lord, if only an information or intimation is given without actually commencing it, my lord. It commences on passing of the show cause notice, on issuing of the show cause notice, that the review petition would come in. Now, just a moment, my lord. I'll quickly second this.
Hmm? Which one? There are many judgments you have given. Which one?
No, my lord, I had given
Now
a.
give the name of the judgment which you are referring to.
Yes, my lord, it's Pallav Seth versus Custodian and others, reported in 2001, 7 SCC 549.
No, it's not it. We have
Well,
given
I have-
many judgments. One is some Andhra Pradesh judgment,
I have a copy.
one is Bongaigaon Refinery, one
That's all
Rajendra
carried, my
Yadav.
I'll come to that later, Bongai.
Don't come so much. So much of judgment is very big. Chairman, Indian Recruitment Board. Yes. Yes, what does this one?
My lord's paragraph, the page 557, paragraph 8. What was the issue before the honorable court? The second line, my lord, page 557.
Para?
Para 8, but page is 557. It's on the next page, my lord.
Therefore,
start.
the only question.
The
which
second
survives
line,
for
therefore, the only question which survives for consideration in this appeal is whether in view of the provisions of section 20 of the Contempt of Courts Act, the special court was prohibited from taking any action, as according to Mr. Venugopal, the court had initiated proceedings for contempt after the expiry of a period of 1 year from the date on which contempt was alleged to have been committed. It is the case of the appellant that the contempt, if any, was committed more than 1 year prior to the initiation of the proceedings. The special court and section 20 of the Contempts of Court Act 71 prohibited the court from taking such action at a belated stage. Now, this was the issue before the court, my lords. Just a moment. Thereafter, my lords, may kindly come to page 566, para 29, 4 lines from the above. What was the contention of the appellant, my lords? He, however, submitted that contempt proceedings are initiated within the meaning of section 20 when the court, on application of mine, issued even a show cause notice within a period of 1 year of the committal of the alleged contempt. Thereafter, my lords, my lord, the page 568, paragraph 35 and 36, my lords, the court went on to see the dictionary meaning of the word initiate, my lords. In Webster's Third New International Dictionary, the word initiate has inter alia been defined as to begin or set going, make a beginning, perform or facilitate the first actions, steps or stages. In shorter Oxford Dictionary, the word initiate is defined as to begin, commence, enter upon, to introduce, set going originally. I pause here for a moment, my lord. The letter by which I was intimated, that did not commence the proceedings, my lord. The proceedings only commenced when I was issued a show cause notice. Now, the findings of the court, my lords, at page 572.
But this order, it's an order. 9-5 is an order and a copy is being given.
Yes,
Then
but it does not commence the proceeding, my lord. Initiate means it has to commence the proceedings of review. And how will the proceedings commence, my lord? That, my lord, would also find in the explanation. It would commence only when I am served with a show cause notice. And it is not only in case of a review of, my lord, in all service laws, my lord, even disciplinary proceedings.
if you go by the service of notice, that can be there.
Show cause notice, man, show cause notice. Because only then I was show cause that a review they're contemplating a review under such and such grounds, what you have to say.
Now, for example, you duck the notice for 6 months, then No,
That is not, yes.
you have to
So
consider
my lord,
that also.
my lord would think the other way around, with all due respect, my lord. What happens if I'm only informed? That thing would loom large on my head that they can at any time in my service career, once they have informed me, they can initiate the review proceedings by serving a show cause. For example, my lords, I was penalized in the month of January, my lords. In the month of March, a similar letter was issued that we are thinking that we will review your penalty. And after that, for 5 years, they do not do anything. And after 5 years, they serve a show cause notice. Now, what Supreme Court had to say, my lords, because here, my lords, the review is a suo moto review. My lord has read the provision. Review can be of two types. One, suo moto, which the appellate authority themselves initiates, and other on application of a party, a aggrieved party. I may apply for a review. Now, paragraph 44, my lord. Action for contempt is divisible into two categories, namely that initiated suo moto by the court and that instituted otherwise than on court's own motion. The mode of initiation in each case would necessarily be different. In the case of suo moto proceedings, it is the court itself which must initiate by issuing a notice. In other cases, initiation can only be by a party filing an application. Now, if it is suo moto, initiation would mean that you serve a notice. And notice upon that person who has committed contempt, in my case, the delinquent employee. The employee should not live under
So
the
your
threat.
long and short submission out here is, if I consider
Well,
the order to be an initiation.
Yes.
Without giving me an opportunity, it would not amount to initiation.
Yes. The proceeding would only
Otherwise, anybody can just pass this order.
be in the file and inform me, and we can forget about it. And after 5 years, he issues a show cause notice
Because initiated, I have done.
that I have initiated earlier. Now, in that Swagata case also, Shaukata Khan, that Andhra Pradesh judgment also, similar thing has occurred. Where the contention of the government was, or the department was, that no, 6 months have passed, but we had called for the records earlier. Records of the case were called for it.
Because in Andhra Pradesh, they say calling for the records is they may like to look into it.
Yes.
Which is different. But here, a conscious decision is being taken that I'll review.
Yes, that decision may have been taken, my lord, but that would not amount to initiation. Initiation would only, it will only start the moment the show cause notice has been served upon you.
No, not served.
No, yes, issued. So it has been admittedly issued after,
Served is different.
yes.
So therefore, your submission is to the effect that whatever may be,
Hmm.
unless there is a procedure initiated, put me to notice.
Exactly. And with all due respect, my lord, the rationale behind that 6-month limitation, why? Because I'll just read it out, I wrote it down. Because an employee should not live under the threat of action for an undetermined period. Now, if what, my lords, they have done, if that is held to be legal, for an undetermined period, the employee would be under that threat at any point of time they can issue the show cause notice. Secondly, my lord, an employee should be protected from action which he would not be in a position to safeguard himself because of loss of evidence, my lord. These are the primarily
Okay,
one
now
of
on
the rationale
parity, what is your submission?
in parity, my lord. My lord, would kindly come to paragraph 23 of my writ petition where I have pleaded, my lord, in ground of parity. 23. Before that, my lord, I may trouble your lordship, my lord, once on paragraph 21, my lord, that order of suspension was itself illegal. With- My lord, okay.
We are not concerned with
No, my lord.
suspension. What am I going to do?
23, my lord, page 18. The petitioner humbly begs to submit that the impugned order dismissal purportedly passed in exercise of Rule 54 is also challenged on the grounds of parity. Incumbents alleged of the same misconduct, Sri G.C. Soikia, Sri G.C. Tai, and D.R. Yen, having been issued similar charge memo, were treated more leniently than the petitioner. None of the above mentioned officials were treated as harshly as that of the petitioner.
What was their punishment?
Such action, it was not dismissal. None of them were dismissed. They have replied to my statement, my lords. The reply, my lord, would find
What
at
did they say?
paragraph 18 of the affidavit in opposition. My lord.
What did they say?
My lord, just a moment, paragraph 18. They say, my lord, I'll read it out, my lord. That the submission made in paragraph 23 of the writ petition being incorrect and misconceived, the same are denied by the answering deponent. The statement averment of the writ petitioner to the effect that incumbents alleged of the same misconduct so and so, having been issued similar charge memo, were treated more leniently than the writ petitioner, and none of the above mentioned officials treated as harshly as that of the petitioner being not correct, the same is denied by the answering deponent, and the answering deponent begs to state that a decision taken by the reviewing authority in case of other officers is based on facts and circumstances pertaining to the cases against them. The petitioner was guilty of forgery and he was also in a habit of committing forgery. That was never the charge, my lord. The habit of committing forgery in respect of tenders, which has been established during inquiry. The gross misconduct made him rendered his continuation in service undesirable and prejudicial to the interests of the company, and also made him liable for harsher penalty than others. It is denied that the action of the respondent authorities is in clear violation of Article 14 of the Constitution of
What
India.
was their punishment? Yes, Mr. Sahayla, what is their punishment? Huh? When there is an allegation being made, how can you?
Well, he is the superintending engineer, he is the main person, my lord, every who has issued the tender, and he has prepared some newspaper, my lord, that is in published there. But these newspapers were not, the original newspapers, the tenders were not published.
Not published.
Not. And they settled those, my lord, tenders.
Better this. Let's see the inquiry report.
Yes, my lord, that is at page 69.
Hmm?
Page 69.
69.
There's also the
Departmental inquiry. What is the finding? There was even this one is the inefficiency will not issue for the published.
several tenders.
Why didn't they publish? Why didn't they publish?
They have shown the file, my lord. They have kept a photocopy of the newspaper where it has been published. But on the same day, the original newspaper is not published. They have prepared on newspaper, printed. and so on, the forgery.
There were 3-4 engineers involved, same rank, my lord. My lord would find that from the additional affidavit, my lord, my additional affidavit. They were all tried together on the basis of an FIR filed by ONGC, but all these people.
How
were-
did he get acquitted?
Hello?
How did he get acquitted?
Not just me, all the delinquents.
That, my lord, public prosecutor do it, my lord, they said to get it.
Beyond reasonable doubt. Not otherwise.
That's right, my lord.
My lord, accused persons, Shri Ranjan Kumar Neo, who is the petitioner, Shri GC Soikia, whom I mentioned, Shri Ganesh Chandra Tai, so and so are present. As per judgment, the accused so and so, the petitioner Ganesh Chandra Tai, Ganesh Chandra Soikia, Dayaram Yen are held not guilty and are acquitted from the offence punished. In the same transaction, what my learned senior fellow, that forgery, that purported forgery, all these people were involved in it. They're all superintendent engineers. My lord calls for the records and asks for the charge memo or the show cause issued to the other delinquents. It be clear, my lord, there was a similar set of allegations. Similar set of allegations. And my lord, the Supreme Court is very clear on that, my lord. There has to be clarity even in cases of penalty. My lord desires,
What was the punishment?
my lord, I'm so sorry, my lord.
How can you say it to be penalty?
Yes, because they were, none of them were dismissed. That's what instruction I
That
have.
you are saying, we don't know.
No, that I can
You want-
undertake to it, my lord.
You want I should go there to
No.
the ONGC?
No, my lord,
Then
I can give an undertaking, my lord. None of them were dismissed from
you
service.
can't give an undertaking. The fact that you are undertaking cannot be there tomorrow, what will you, because they deny it.
No, they are not saying. They are saying if my lords read their affidavit in opposition, they are not denying the fact that the others were given less harsher penalty. They say I have been given harsher. In that case, that's an admission that the others were given less harsher.
And what was the position of those other officers?
Superintendent engineers, my lord. All superintendent engineers.
No.
Yes,
Is
my
it-
lord, all superintendent. I'll read the judgment, my lord. Shri Ranjan Kumar Neo, Girish Chandra Soikia, Girish Chandra Tai, and Shri Dayaram Yen are found to be involved in committing forgery by usage of fabricated and bogus documents in respect of tender number so and so floated for civil works in the year 2010. Everyone was equally involved, madam.
But are they, everybody, the superintendent engineer, because there is a question of trust also.
Right.
Whether they enjoy the position of trust, loss of confidence, there are many aspects which are
Yes.
critical,
In cases
How
of-
can you allow a person who is, just give them a year? Anyways, we'll hear it again on Tuesday, when it's
Well-
Thursday, Tuesday. Next Tuesday, huh? Next Tuesday at 2. Hearing remains inconclusive, Mr. matter again on so and so at 2.